Directorate of Higher Health Services, Lordship. So I need a 2 weeks time, further time, Lordship.
Actually, my lord, they should expedite it. It's a,
Yes,
it's a pension matter, my lord.
Hmm.
In 31/1/18, I retired. She's a lady, my lord, without
See,
husband.
18 she retired.
Yes, Lordship, but we are processing, Lordship. So after 2 weeks, Lordship, I'll get the
This is the last chance.
Yes.
After 2 weeks, I'll give a date. On that date, you have to file, otherwise we'll proceed.
No, we have filed our affidavit, just some certain.
Some instructions,
Yes.
okay. If it was,
They are finalizing it only, they are taking time.
Otherwise, we are processing, Lordship.
okay, last chance. I heard Mr. K.N. Chaudhary, Learned Senior Counsel, assisted by Miss R. Kakuti, Learned Counsel for the Petitioner, and Mr.
D.
D. Upamanyu, Learned Standing Counsel for Health.
Yes, Lordship.
For Health and Finance? No.
Health and Family Welfare Department.
Health and Family Welfare Department. Mr. Upamanyu, Learned Counsel seeks some time to get the full instructions from the
Lordship, from the Directorate, Lordship.
Directorate of
Health Services. As well.
from the Directorate of Health Services. It is noticed that the matter pertains to the year 2023, and the petitioner had retired
On
in the year
31/1/18, 31st of January 20.
on 31st of January 2018, and she has not got pension since then.
And other benefits, only provisional pension I am getting.
Acha. And other benefits except the provisional pension. As such, Mr. Upamanyu is given a last opportunity to get the instructions.
No, Lordship, this has been sought from the government to the Directorate. So, Lordship, I will get it within 2 weeks, Lordship.
Last week, but 2 weeks. Last chance to get the necessary instructions. List this matter on, okay, I'll give you a longer date than 2 weeks. Today is 13th.
Yes, Lordship.
So 27th will be 2 weeks. So 3rd of June,
Yes.
Highly obliged.
right? On
Highly-
3rd of June, on the said date, Mr. Upamanyu will place the instructions. Otherwise, this court will proceed without the same.
Deeply.
Obliged. Lordship, with regards to item 24 to 27, Lordship,
Mm.
in 25, 26 and 27, we have filed our affidavit.
Wait,
In
wait, wait.
24, Lordship, we are filing.
Just a minute, just a minute. 24 to 27.
Yes.
Yes, what happened?
25, 26, 27, Lordship, we have filed our affidavit. 24, Lordship, we have just received the signed copy, Lordship. We will be filing it during the course of the day.
You have
I
for the
informed the
petitioner?
petitioner.
Okay.
Date may be fixed.
Huh, huh.
Yes, Lord.
Mr. D. Upamanyu, Learned Standing Counsel for Health and Family Welfare,
Yes, Lord.
Family Welfare Department, seek some accommodation in respect of item number 24, some accommodation to file the affidavit. Prayer is allowed. List this matter on 28, 28
Lordship,
or 29.
29.
29th of May 2026. In the other matters, you write 25, 26, 27 or Koba. The
Pleadings are complete.
the said case to come up along with the item 24 on so and so date. List this matter on so and so date. There you have filed your affidavit.
Yes, Lord. Highly obliged.
Lordship, I beg to mention item number 62, my lord, of hearing follow.
62 of daily supplementary. There are so many matters. Bapre, this is a long list.
This matter may be taken after 2 weeks, my lord. I have already taken the consent from others.
There are 93 matters. I'm surprised to see. Acha, there are some analogous, but okay, which matter are you talking of?
62, my lord.
62.
Yes.
Acha. 62. Wait. 62, yes. What has happened? 2020 matter.
Yes, my lord. After 2 weeks, my lord, today we have some person.
You're for the petitioner.
Yes, my lord. I have already taken the consent.
I'm
from
for
others.
the respondent.
But 2020 matter.
Yes, my lord.
5 years have gone by. So I'll fix a date. On
Yes,
that
ma'am.
day, you please
Yes.
do it.
On that date, ma'am.
Okay. The Mr.
V. Kumar.
V. Kumar, Learned Counsel for the petitioner, prays for some time, as he has some difficulty in doing the matter today. Prayer is allowed. Mrs. A. Gayon appears for Learned CGC, appears for respondent number 1, right?
The
For,
respondent, all respondents.
for all the respondents. Prayer is allowed. List this matter on, when do you want?
5th of June.
5th of June.
Yes, ma'am.
Okay, list this matter on 5th of June, 2026. On which date?
Yes, ma'am.
The endeavor should be made to dispose of the
Yes,
matter.
ma'am. Must.
Much obliged.
Please, your ladyship. I beg to mention item number 61 with the concern of the other side. Today, the matter can be.
2017 matter, older.
Ladyship, my senior Relative has been deceased today.
Oh, your seniors?
Relative.
Oh, acha. Okay, okay. Acha,
My lord,
item
very-
61, you are for the petitioner?
No, I am from the respondent.
My lord, I am for the petitioner.
You for the
Fixed on my lord, 19 May,
Uh-huh.
19 May.
19th May?
He paid for a date.
Acha, you want it on 19th of May?
Yes, ma'am.
Okay, respondent side, you are agreeable, right? 19th?
Yes.
Okay. Mr.
K. Kolita,
K. Kolita, Learned Counsel for respond number
1 to 5.
1 to 5. 1 to 5. Praise for some time. As his senior is, what do you say that? Bereaved.
In period.
Delinquent.
Relative is as his senior has some personal difficulty. The prayer is not opposed by Mr.
P. Hazarika.
P. Hazarika, Learned Counsel for the petitioner. As such, the same is allowed. List this matter on 19th of May.
Obliged.
You are mentioning or you are doing?
Lordship,
I was ready to do the matter, but he comes and says that
Lordship, the affidavit is not there, your Lordship.
Which matter?
Lordship, item 22, your Lordship.
22.
my lord, steps are complete, my lord. Private respondents are there.
Mm,
On the last occasion, he prayed for the time to file his counter.
okay. File his reply.
Affidavit in
No,
opposition, my lord.
affidavit is not.
You are for petitioner?
I am for the petition, your Lordship.
Okay. So, so you will file your affidavit in reply?
No, Lordship, there is no affidavit opposition yet filed.
We have to file, my lord.
Oh, acha, you have not
Right.
filed.
We and both the
Private
private
respondents.
respondents, my lord.
Acha, okay. Heard Mr. Forgot your name.
TJ Das, your Lordship.
TJ Das, Learned Counsel for the petitioner, and Mr. Yes,
D. Gogoi, my lord.
D. Gogoi, Learned Standing Counsel for
Assam Agriculture University, my
Hmm?
lord. Assam Agriculture University, my lord.
Assam Agricultural University.
University, my lord.
It is stated that the respondents, both the official and the private respondents, are yet to file their response. And as such, time is sought for. Prayer is allowed. List this matter. When can you file it? Along with the,
3 weeks, my lord.
list this matter on
After 3 weeks.
10th of June,
10th.
10th of June, 2026.
Much of them.
Wait, please, Your Lordship, I beg to mention daily list 38 and supplementary list 91, Lordship.
Wait, daily list 38.
And supplementary list
38, what happened?
38, actual Lordship, my senior is out of station, Lordship. That's it.
Mm-hmm.
Senior is out of station, Lordship, that is the problem.
Okay, and, okay, write in 38. Learn, you are for the petitioner?
Yes, Lord.
Learned, Mr.
And Ali on behalf of Bidega.
N. Ali, Learned Counsel, on behalf of Mr. D. Deka, Learned Counsel for the petitioner, submits that his senior has some personal difficulty in doing the matter today and has prayed for some time. Prayer is allowed. List this matter when? After 2 weeks. 25 matters, so I'm giving 10. List this matter on 3rd of June.
Okay.
3rd of June 2026. Which is the other matter?
Lordship, supplementary 91.
91. 91, yes. This is also 25 matter. Same prayer?
Yes.
Same, huh? Same order in 91.
File your-
Yes.
Item 1, for everyone.
If I need to know, Mazur to do something. Ouch. Just a minute, just a minute. Oh. Yes, yes. Item number 1 is for what? Admission.
Admission, Lord. May I please, Lordship?
Additional affidavit you are supposed to file
No,
to bring on record certain documents.
for if that was his prayer.
Oh, this was 23 order. Okay, you must have
No
filed.
need to file, Lordship.
In fact, Lordship, if Lordship goes to page 9, Annexure 1, Lordship,
Hmm,
this is a covered case. In fact, Lordship, they settle law. Law is very much settled, Lordship.
hmm.
The person concerned is appointed against a personal post, Lordship. So
Hmm.
he is not entitled for promotion. It is settled law, Lordship.
Personal to the incumbent.
Yes, Lordship. The personal post, Lordship.
So here he is praying for promotion.
Law, Lordship.
So what is his name? Condol Das. 33.
33, serial number 33, Lords.
PL number 32.
Let him start, let him say what is your right for promotion?
Lordship,
You are appointed as what?
no, I am appointed under personal post. Subsequently, my post is regularized in the year of 2000.
Post of what?
Post of Khalasi.
Acha, grade 4.
Grade 4 post.
Acha. Then it was regularized.
Regularized, subsequently regularized.
Where is that order?
Page
This
9.
Page 9, page 9,
Page 9.
page 9.
Page 9 where it is shown that he was regularized.
Not this.
Second line.
Second line.
Finance
I appointed-
department following are appointed for purpose of regularization of services. See the English. What does they mean?
Lordship,
What do they mean? A finance department, the following master role workers are appointed
for the
for
purpose
the
of regulation.
purpose of regularization.
They are already in service as a master role worker, Lordship. So
Acha.
they are regularized,
So regularized in 2005.
Lordship,
2005.
They were appointed beforehand.
beforehand.
1986, 1 to 86.
1 to
86,
86. So they are regularized in 2005.
2005.
Then how come it is still personal to the incumbent?
Lordship, Lordship. The post will be abolished as and when he is relieving with the post by any means, Lordship, retirement or any means.
Acha, after that what happened? Regularized then?
After
They-
then, petitioner has filed an application for promotion for the post of grade 3
Hmm.
from Khalasi to assistant engineer, electrical engineer. So whatever be. That representation was subsequently forwarded to the for consideration. Lordship, page 19.
Hmm. Hmm.
Page 19.
So this
18,
is for favor of your kind. This was forwarded to the superintendent engineer. Then
that it is forwarded. Then thereafter it is not considered. Now, thereafter this late petition is filed. Now the question is whether the person concerned appointed under personal post can be promoted or not after regularization. Or see, it is, though it is settled that it cannot, but our coordinate bench, once it is held, it can be, Lordship. I have a judgment.
have you any, what is the other, this is what? Additional affidavit. What additional documents we have brought on record?
Additional document.
You are not aware.
Never.
Acha, there is a judgment by Justice Koteshwar Singh
What is the thing?
and a judgment by it's a common judgment by, oh yes,
Yes,
Koteshwar
yes,
Singh
okay.
only.
And-
So
and-
here the
They-
court had
they-
allowed.
and court allowed. So
If-
court, it was held under that way, that once the person concerned was promoted,
Hmm.
thereafter the department said that no, it was wrongly promoted, they reversed their order. That revision was challenged, the Justice, Mr. Justice Koteshwar Singh allowed, no, it is held that they can be regularized. So
So these are also personal posts.
these all are all in personal post.
So this is your case.
This is my case.
Yes, Mr.
In fact, Lordships, the divisionment's order I could place before Lordship. It is also.
He is saying that it's a settled law that he cannot be,
Lordship,
but then there are orders by this court.
yes, Lordship, again, Lordship,
Lordship
can-
can kindly allow to some extent subject to the vacancy outcome of vacancy.
there can.
I am at the part of retirement.
If somebody is wrongly also promoted, Lordship, there is instances of reverting back to his original post of grade.
But then those two judgment they challenged and it was again set aside, reversion order.
That I have not go through, Lordship. I have
Acha,
to-
even I have not gone through, but then I see it here.
Oh.
This is a very old judgment. You don't have anything from the Supreme Court or so.
Supreme Court, Lordship, this matter relates to Assam only, Lordship, perhaps. In
It's
fact,
very old
Lordship,
now.
here is a case, Lordship, where the person concerned was promoted to the post of grade 3. Then, Lordship, it was listed before coordinate bench of the Assam court. He has reverted back him to the original post of grade 4, Lordship. This is another judgment, Lordship.
But then the posts are still there. It's not abolished.
once the person relinquishes the post by any means, Lordship, by retirement or by death, it will be relinquished, Lordship.
But till he does not retire or dies,
The
it
post-
will continue.
It will continue.
But without any promotional
It is
avenues,
the ex-cater post, Lord. This judgment, Lordship is in hand, Lordship.
what is the,
It is clearly said it is ex-cater post. From paragraph 8, Lordship may kindly see. Paragraph 8, Lordship may see, the court analyzed the concept of personal post and noted that the regularization of service of the MR workers were not against any cadre posts of the department, but the posts so created were to be treated as ex-cater posts. So this division bench judgment is very much clear on that point, Lordship.
so at least endeavor should be made to make the post cadre post, I mean to include them. No?
That, Lordship, I'm not in position to say, Lord. Because
But just see Justice Petitioner's judgments, whether he has referred to anything.
Paragraph 8 and 9 related.
somebody was probably wrongly promoted, Lordship.
No, that
So,
of course
yes.
cannot be a precedent, cannot
No.
be followed.
Lordship.
It was distinguished, right? No, those cases are different, Mr. Counsel. There, of course, promotion was granted to them,
Granted.
but not on the ground of, and when it was reverted, right?
Right.
Not on the ground that it was personal post. So that reason was not given.
That reason was not given.
That's how the
So,
case is
correct.
differentiated.
Differentiated.
Here it is said, you see, promotion upgradation was not proper on the ground that they were holding personal post. Yes, it is seen that the authorities never took the decision that the said promotion was not proper on the ground that they were holding personal post, which would disentitle them. Right. So these judgments are not also cannot help you.
They were holding personal post.
No, in that judgment, it is not said that the promotion, that reversion was due to the fact that they were having personal post.
Yes, of course.
So that is a different thing. Now you pray for promotion,
Yes.
whereas you knew that those were personal posts. And regularization, of course, was given, I mean, to make you
It
feel
was
good,
one-time measure, Lordship.
kind of make you feel good. So this is a case for
He
dismissal
entitled to
rather.
pension and other Lordship benefit, but not entitled for promotion.
Promotion, what is a prayer here? So anything more, Mr. Counsel?
No, nothing.
Case for dismissal. Okay, heard, mister?
B Fukon.
What are these judgments for? Same judgment,
Same judgment. One is review.
huh? One Justice Surana's judgment is there. This is on what?
Purana judgment I am not placing.
Mr. Upadhyay, you have
Lord,
given,
I
I
had
think.
placed. Here
On the same line.
Here the petitioners were promoted, but court held that this is wrong promotion, so they were reverted back, lords.
Oh, acha. This is what you have just said.
Yes, yes.
This is what? State appeal? No. State, no.
No. See. They came against lordship reversal
Oh.
when they were reverted back, lordship.
So it was dismissed?
Dismissed, lord.
Hmm. Okay, right. Heard, mister? Your name?
B
please?
Fukon.
P. Fukon. Learn B. Fukon, learned counsel for the petitioner. And Mr. Upadhyay, what Upadhyay?
N. Upadhyay,
And Upadhyay,
the
learned standing counsel for
Irrigation department.
Irrigation Department. By this application, filed under Article 226 of the Constitution of India, the petitioner has prayed for promotion. Petitioner has prayed for his promotion to grade 3, from grade 4, from grade 4 employee, Khalasi, to grade 3 as assistant electrician. Para. It is the case of the petitioner that he was appointed as a Khalasi in the assistant executive engineer in the office of no. In the assistant executive engineer, what in the executive? Under the office of executive engineer Gauhati, under the office of executive engineer Gauhati division, executive engineer Gauhati, irrigation division, Bridia. And that he was engaged as master roll worker on 1/2/1986. And since then, the petitioner has been working in the said office. Full stop. The petitioner further states that his services was regularized with effect from 22/7/2005 in pursuance to an order dated 6/10/2005 issued by the executive engineer Gauhati division within bracket irrigation. Para. The petitioner had also stated that he had obtained provisional workman permit on 10/7/1995. And that he has applied for his promotion to the post of assistant electrician on 24/2017 before respondent number 4. Where was the forwarding letter?
Page number 19.
Respondent number 4. 2. The executive engineer, Gauhati Division Irrigation, who had forwarded the same to the superintending engineer, Gauhati Project Circle, Irrigation within bracket. On 3/6/2019. Full stop. The petitioner had also petitioner also has stated that he had filed another representation before respondent number 1, but the same was not paid any heed to. The learned counsel for the petitioner submits that although the petitioner was regularized to his post of Khalasi by order dated 6/10/2005, but the post that the petitioner was holding was personal to the incumbent, but he submits that the petitioner, due to his long service career, has prayed for promotion to the post of grade 3. To substantiate his argument, he has placed 2 judgments of this court by filing an additional affidavit. On the other hand, Mr. N. Upadhyay, learned standing counsel for Irrigation Department, had submitted that the post held by the petitioner was personal to him, as could be seen from the regularization order dated 6/10/2005, wherein the petitioner appeared at serial number 33 and that the petitioner is not entitled for any promotion being working in a post personal to him. He had placed reliance on the judgment of the division bench of this court division bench of this court in Dilip Talukdar and others versus State of Assam and others, reported in 2017 2 GLT 135, by which this court held that the concept of personal post was analyzed a number of times, and it was also noted that regularization of workers working in their personal post were not against any cadre post of the department, and the said workers are not entitled for any promotion to any promotional post, to the next higher post. He had also relied on the judgment of this court delivered in writ petition number 8985 of 2019, by which this court had held that reversion to the earlier post held by the worker, which was personal to him, was correct. I've heard the counsel and have gone through the records. It is seen from the regularization order 6/10/25 or 2005 that the post the petitioner was holding since 1986 was personal to him, and it is no res integra that there is a difference between workers continuing in an encarded post, in the feeder cadre, and the workers working in post personal to him. Promotion, full stop, promotion to a higher rank can be considered only from the feeder cadre. And since the petitioner was not encarded in the feeder cadre, he cannot claim promotion to the next higher post. Full stop. It is also found that the services of the petitioner was regularized temporarily against personal post. And the said petitioner cannot turn around and claim promotion to the higher cadre post. The judgments that the petitioner had annexed to his additional affidavit was on a different footing. In the said judgments, the facts were different. The petitioners were reverted to their original post, not on the ground that he was continuing in his personal post, but on some other ground in those cases. As such, the reversion was held to be banned. But in the present case, it is crystal clear that petitioner was working in a post personal to him, and as such, he cannot claim promotion to the next higher post. However, it is open to the petitioner to make representation before the authorities to include the said post as cadre post. They can make a representation as cadre post in the service rules. No, in the hierarchy of the post in the irrigation department. Petition is disposed and dismissed.
Alright,
Cannot do anything.
cannot be lost, cannot.
He could have brought some judgment, but those judgments are not applicable. Okay? Because I had seen only one judgment. What is the other judgment? That was review.
That is review.
Review of the same.
With review.
Oh, acha.
Review was allowed.
Two and three. Yes, miss.
Actually, I haven't received any instructions regarding this matter.
You are for the petitioner.
Yes.
You are yet to bring the instructions. Instructions from this side.
Letters are infractions, my lord.
Instructions? Why? How come?
In item number 2, my lord, these are my instructions.
Acha.
They have submitted some fake bills, my lord, and challenges the suspension order, my lord. They have already paid the amount, half amount, my lord. The remaining amount has been deducted, my lord, from the salary. They have been reinstated. Department proceedings have been initiated. They have been penalized, and they are now in the service. So nothing remains, perhaps.
Still, ma'am, I seek for.
Okay, you take instruction on the basis of this, right? Okay, you will file or you will just give the instructions to her? Or you file an affidavit?
What should, whatever directs, my lord.
File an affidavit so that they can also go through. This is by Jayanta Pathak too?
Yes, my lord, the petitioner, my lord. He wrote.
Oh, he is the petitioner.
Yes, my lord.
He had written a letter to the APDCL
Yes, my lord.
stating what? Returning the medical
That he is
reimbursement
intending to
money
return all the amounts, my lord.
and allowed to reinstate in my service.
Yes, accordingly, my lord, he has paid, my lord, on the next page, my lord.
Huh.
He has paid, my lord, 6 lakhs in check, my lord. And the remaining, my lord, it will be deducted in 16 installments, my lord, which has been deducted already.
He is still in service.
Yes. Yes, my lord. And last page, my lord, he has been reinstated, my lord.
That means he had availed the availed the medical bill
Those-
wrongly
Yes, my lord.
by depositing fake bills.
Yes,
Acha, acha, acha. Now that has been recovered from him.
yes.
A disciplinary inquiry was also conducted.
Yes, conducted in, my lord, he has been penalized also, last page, my lord.
Penalty in the nature of what?
A penalty in the nature, my lord, in the last paragraph, my lord, in view of the facts, the charges against Jayanta Kumar Pathak Sahayak have been established, and thus he is penalized for the same by deducting 2 consecutive.
Acha.
increments.
Which will be penalized. And you have returned.
Have any instructions? Kindly. So
Okay.
for that reason.
Heard, Miss
Dash.
T. Das, on behalf of Learned Counsel, N.N. Jha,
Yes.
on behalf of Mr. N.N. Jha, Learned Counsel for the petitioner, and Mr.
B does, my lord.
B. Das for APDCL,
APDCL.
Learned Standing Counsel for APDCL. Mr. B. Das has placed an instruction that the petitioner had returned the money taken by him for medical treatment,
Yes, ma'am.
which was found to be fake, right? Which was found to be fake, and that a disciplinary proceeding was also initiated against him, and a penalty of stoppage of 2 consecutive increments were imposed upon him. Oh, not stoppage, deducted.
Deducted, ma'am.
A penalty of deduction of 2 consecutive increments were imposed upon him. However, Ms. Das, Learned Counsel for Das, right?
Dash.
D dash, Learned Counsel for the petitioner submits that that she does not have the proper instruction. Our hated likhide agot, and as such he submits. Herita, he submits that the matter has become infractuous. However, Ms. D dash submits that she is yet to get the proper instructions. In view of the same, the Learned Counsel for the APDCL is directed to file an affidavit, bringing on record the instruction that he has placed today. List this matter again on which date? On 2nd of June or 1st of June?
No problem.
1st of June, 2026. What is the other matter? Same.
Same, my lord, same.
Same order in other also. The person is different.
Different name, Subendu Roy, my lord.
So that is also medical reimbursement
Same-
and fake bills.
Same
Same one.
obligation.
Yes, Mrs. Sekar?
Yes. This is relating to my lord, that I have challenged the appointment of respondent number 5 because my lord, the selection committee has failed to.
You were not
Promote
appointed, but
attendance.
respondent number 5 was
I'm
appointed
for
in your place.
The principal,
Hmm.
lordship the principal,
In charge? No,
no, my lord, regular principal.
principal.
So there is a guideline, my lord, for appointment of the principal. They have filed to
1253,
comply.
1253 of 2018 rules or what?
Yeah, my lord, we have
3-1.
already.
Lordship, I am for respondent number 2, 3, and 4.
Hmm.
Lordship, we are awaiting for instructions. We need a 3 weeks
Instruction.
time.
Just
What?
1.5 year pending for judgment, my lord. 1.5 year pending for judgment. We have submitted the written argument also. And my lord, he has also submitted written argument. Everything is over. And
Hmm.
my lord, after 1 year, the matter has listed. Although they have taken time, RSI has taken time for 1 week.
Hmm.
But the matter was listed, my lord, after 1 year. This is also my last name. So my lord, the story, facts of the case is very simple, that I am also working in that school. He is also
Hmm.
working in that school. But my lord, his husband was passed.
Okay, we will
Was
give,
earlier, he was
okay, I'll
appointed.
give her last chance to file, to get the
No,
instruction.
whatever file, they have filed. Everything is filed.
No, some more instructions.
Yes,
What
Lord.
Yeah, otherwise affidavit is there.
Yes, Lordship.
Everything
Huh?
is there.
When your worship there, when the two set of council has come, then.
No, no, that cannot
Otherwise,
be.
I am ready.
He is
Lordship.
ready, so me command recommendation, you have nothing to do. Whatever is done, it is done. If it will also filed 2-3 times.
Like, cannot force her like this, but,
Borolan, no.
uh,
Borolan has time because it was continuously heard by different courts, my lord,
Hmm.
earlier.
Hmm.
And it was reserved by court earlier, my lord, for 1.5 year. For reserve for judgment, again it was released. And my lord, in details, they, my lord, after hearing the court, my lord, court has again, my lord, directed to file fresh affidavit. So they have 2-3 affidavits they already filed. So
now you are appearing for BTC,
Yes, Lord.
BTC council.
2 and
is separate
3.
council.
2, 3, and 4, Lordship.
2, 3 and 4.
Yes.
Inspector of
Queries there.
Udalguri. Otherwise, your affidavit is on record.
Yes,
Everywhere
Lordship.
records.
Lordship, give us some time, Lordship.
Okay, I'll give you 1 week's time only. Right.
1 week, last time
Positively
also
by-
1 week time was given and it was listed after.
No, I'll record in my order that no more adjournments.
Then, so my request is your Lordship may kindly hear it. And if it is required, then your Lordship may give time. Otherwise, not necessary to keep us headache pending. Because my.
She is accountable again. She was advised to take time. 1 week, I'll fix a date.
My lord, she is a junior, she don't know much about the facts. Your Lordship can at least allow us to submit the case. And written.
No, there is no problem. I should allow you and my duty is to pass judgment. But then,
What happened when every week cases are listed that are not disposed of? For this reason, that reason.
otherwise you can
government
call
only-
your
for the
senior.
Government only.
Lordship,
cases are
kindly
absorbed.
give us some time. She is on legs, Lordship.
She's on legs after some time.
No, Lordship, kindly give us some time for acquiring the instructions, Lordship. Kindly.
Only, okay, you do it on,
Only because, my lord, because government has already filed the affidavit while this selection only, there's a, my lord, here, that's when a very different, small difference, my lord. That is, my lord, regarding following the guideline. That is, my lord, he could have allowed only he has, my lord, continually serving as, my lord, in such head principal as 1 year. But more than 1 year, then he will be allowed 1 mark. But he has been allowed 1 mark, but my lord, he has completed only 6 months. That is the case, my lord. So my lord, he's not entitled to get.
Client has already been appointed.
That is true, my lord. My client has principal, yes.
Acha. This
My-
is district wise it is done, right? So
My principal has already appointed his principal in different school immediately.
then what grievance you'll have?
No, my lord, he has been, my lord, it's a prestige issue for him. Because, my lord, academically also his career was brilliant.
So
My
you
lord,
want it
once
from
he has
an
set aside,
earlier
set
date or
aside.
what?
Earlier, my lord,
No, you want the post of principal with effect from some earlier date or what? But you are appointed as a principal.
I'm appointed as principal.
So what
Thing
grievance
is
now?
that, my lord, earlier, my client approached this court earlier also, then his appointment was set aside.
Huh.
Thereafter, as per direction of this court, my lord, selection was held. Again, they have made some illegalities in the selection.
Mm.
Then, my lord, he has approached this court again. But the case is from 22, my lord, it's pending. It's an old case.
Now what
22,
is your prayer?
fundamental. It's better set aside, my lord, because why he will be illegally selected? First selection should be held. That is the thing.
Oh, you are against S105 only.
Exactly.
Otherwise, you don't want anything for yourself.
No, my lord. I don't want anything for myself. Only the why he has been illegally selected. That's the my lord criteria left now. So,
But whether that
first
can be
selection
done.
should be held. It should be set aside.
When you don't want- you don't-
Illegally is done.
But you don't want any relief for yourself, only to set good the other person.
One should not be illegally given minor benefit. Once when the court set aside this appointment earlier, then again first selection was second time also, maybe some his godfather is sitting, that's why he's been again illegally appointed. So it's a ego problem from them, and when it is illegal is done, that is the law.
But whether writ can be
Laws of-
issued in such circumstances?
So,
Whether writ can be issued in such circumstance?
it can be issued manner if the illegality is made in the selection, in violation of the guidelines.
No, you have to show your grievance, that you are
At this
aggrieved.
time, grievances do are.
Personally, you
My
might be
fine,
aggrieved,
yes.
but then
And my fine, I have challenged the selection only, nothing else. Because otherwise also, if he is my lord nullified, then the first selection will be held.
where you will not be considered.
He will not come. He has already regularized.
So you will not come. But asking for a writ where you are not aggrieved,
I'm aggrieved by
because
illegal
legally
selection.
you have to be an aggrieved
I'm
person.
aggrieved by illegal selection.
Your lordship may hear, your lordship hear the matter.
Anybody can.
Anyway, she wants.
Your lordship.
Uh-huh.
I am ready, your lordship.
But then BTC wants some time.
BTC has already filed 2-3 affidavits, all instruction has been given. So some person, and then there are so many set of councils. So many set of councils.
Not
they-
2 weeks. If I can give only 1 week, I can.
The next Tuesday, my lord.
Next Tuesday.
Lordship,
Next Tuesday.
next week I have some difficulty, your
Yes,
lordship.
got
On
difficult.
28th, your lordship.
No,
28.
my lord, then my lord, it is difficult, my lord.
No, next week, the entire 5 days.
Lordship, number of cases are fixed, so that is why, your lordship. If
Now see where your lesser
Monday-
number of cases
Monday,
are
my lord,
fixed.
then. Let it come on Monday. my lord.
then your lordship may fix it on 21st,
21st.
Thursday.
Okay, Thursday. Right.
The Monday-
Okay.
Monday na honey.
মোৰ বেলেগ কেছ আছে বাইদেউ, দুই এটা কেছ থাকেতো।
It's not dueta, it's so many of them. And so heard Mrs. N. Saikia, learned counsel for the petitioner, and Mr. S. Borthakur, learned senior counsel, assisted by Mr. P. Khatania, learned counsel for petitioner, and Miss L. Borgohai, M. Borgohai, learned counsel for respond number 2, 3, and 4. 2, 3, and 4. Ms. Borgohai
My lord.
submits that they are awaiting some further instructions from the department and has prayed for some time.
জুনিয়ৰে দি দিব।
Prayer is allowed.
What will you?
However, the learned counsel for the petitioner objects to the same.
Document diya nahi.
As such, only 1 week's time is granted to the learned counsel to get her instructions. Accordingly, fixed a matter, accordingly, list the matter on 21st of May, 2026,
Lordship,
as a
give me
last
of that.
chance. Prayer is allowed, no, as a last
Hold on,
chance.
my lord.
Prayer is allowed as a last opportunity, as a last chance.
And that,
Lord.
an endeavor will be made to dispose of the matter.
Ha, ha,
Again, listing.
On which date an endeavor would be made to dispose of the matter. Next date, I will.
Listing on.
Only because she is requesting a lot. 57. Oh, 5 to 7. Yes, 5 to 7. Yes, Mr. Counsel.
Sorry to mention this, sir. Item 52, my lord, it was almost start. Can it be taken at 2 o'clock or my lord, during the course of the day, otherwise it will not reach. left of-
Okay, 52, call at 2 o'clock. Amanda? It was heard by this bench. It was heard by this bench at 2 o'clock. Yes, Mr. Counsel.
Lordship, in this case, the petitioners are claiming retrospective effects of their permission from AG1. I am, the petitioners are serving in Code Corporation of India.
Hmm.
From AG2 to AG1 on the premise that on the date on which the promotion process was.
Promotion. You want a retrospective promotion?
Yes.
Acha, just show me the, Mr. You're ready?
Yes.
This is it. I'm taking up item number 5,
Fine.
6633. One second, I'll just see the. All the respondents are represented? They are private respondents?
Private respondent, ma'am.
You're for
I
a,
think notice, I am for the food
Notice
corporation
was
of
served
India.
to everybody, but none has appeared.
oh, notice is served.
Every.
Yeah, Mr. Singh, you are appearing for 1 and 2.
I'm appearing for the food corporation of India, respondent number 1 and 2, my lord.
3 to 34.
No.
No representation.
No.
But without their representation, none of the private respondents are represented.
Notice was sent to everybody, acknowledgement was also received. Your Lordship, the order dated 28/11/24,
Mhm.
the last order was before.
28,
28/11/24 from this court.
28, 11, 24.
54.
Wait, there are so many orders after that.
Now, only one order is afterwards, then actually what happened in this case,
Well, I think in the lodgement court, the notice has been accepted.
Mm,
They were served through the journal office.
they were served.
They were served.
Their signatures are there.
I have to verify it.
Acha. But
that's the. You have a duly
Office
kept,
note may be there.
Your Lordship.
when is the large order? Any idea? 23. Notice was, okay, I'm getting that order. Notice was issued upon 3, 5, 6, 9. What about the others?
I can see.
Your Lordship, the notice was served from 3, 4, 5,
Mm,
6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16,
mm.
17, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27,
Mm.
28. Dilip Kumar Upadhyay, I think, and 29 and 33. These two people, either they have left or they were transferred out of this region.
You're not claiming any relief against them. They will be
No,
affected.
They will be,
I'm
naturally, they will be
saying-
affected. That's
They
why
will be
they have
affected.
made respondent.
I'm claiming seniority among, from, against, above them. I want, they are all junior to me. From serial number 3, they are all junior to me.
So respondent, these are served otherwise.
Yes.
9, 32, 33, 5, 12, 15, 16, 18, 17. The same order. So who is required to be served?
these two people, they were not, this was mentioned also in the proceedings earlier.
Mm.
29 and.
So
30.
3, 5, 6, 9, 12 to 23, 26 to 28, these have been completed.
Yes, sir.
29 has been received with unserved. 29 is not served. And 29,
33.
there is a prayer for striking of his name.
Yes,
29.
29. I think I'm just forgetting, either he is transferred out of region or one has expired.
Acha. Only 29 is left.
Discuss.
Only 29 is left.
29 and 33, there, these two,
29 and 33.
33. Mandas.
But 33, it is said it is served.
Notice was, sir, but he is out of this region. Though he is senior, seniority will not count.
So except 29, Mr. Singh, everyone is served. But they have
The office note of the law gym, I think on 31/8/2023. There it
That-
is detailed.
shows yes. But who is respondent number 4? So many respondents. 4 is nowhere mentioned.
The pen number 4, Rajiv Das.
So the Lawajima court's report does not show that he was served. But he was left out. Only 29 there is a remark. So Mr. Singh, what to do? Shall we proceed or? But then this is long back. Lawajima court's report is of 23.
23, my lord.
After that, what did the court say?
No, that notice may again be issued then.
This matter was
That's one.
clear.
Hmm?
This matter was, and there was order that the case can proceed.
There's an order. Where?
My lord, to assist the court, I will verify all these 3 cases.
You please verify,
May-
otherwise it's taking
Maybe
time.
taken up first week of June then.
Your Lordship, now find a remark. 29 and 33 moved out of zone. They have moved out of this zone.
June.
Yes.
But let him verify about all the respondents, huh? Because I cannot find few of the respondents' number in the Lawajima court's record, Lawajima court's report. Let him verify because it's taking time. We will proceed again without their presence, but we'll have to give some regions. So the regions that I have to give, you just cull it out that these are served. In a sheet of paper, you write it and let me know. Okay. Heard, Mr. Gupta?
G.K. Gupta.
G.K. Gupta, learned counsel for the petitioners. There are many petitioners.
Yeah, many people.
And
Three
Mr.
cases,
V.
3 cases, 3 petitions.
3 petitioners in 3
Three
different
cases.
suits. I mean,
Okay. And Mr. Singh, V.K. Singh, learned counsel for the FCI, learned standing
FCI.
counsel for FCI. It is seen in the office note that few of the respondents were not served with the notices. And the respondents and the private respondents are how many in numbers? Respondents are 32 in numbers.
32 in-
Mr. V.K. Singh, learned standing counsel for the FCI, submits that he will cull out the respondents who were not served, and as such has prayed for some time. Prayer is allowed. List this matter
On 3rd
On-
June, my,
huh?
3rd June.
On 3rd of June 2026. That day we will take it up.
Pledge.
Yes. Yes.
Item 9.
May I break the lordship?
Mm.
We're required to file the affidavit.
Affidavits are already there by some
Lordship, may I kindly produce the order dated 11/3/26.
11-3.
Lordship, 11/3/26.
24/4. The last order, my lord, 24/4/26.
No, Lordship, 11.3, the reasons were given why the state respondents are required to file their affidavit.
Achha. Last time, Mr. TC Chutia took time to file
Lordship.
affidavit. So that affidavit has not been filed?
No, Lord.
Mr. Chutia will file. I am appearing for opponent 4.
Yes, Miss Bhattacharjee. See whether the affidavits are filed.
That affidavit by respondent 1 and 2 has not been filed, Lordship. Others have filed.
Chief, it seems that instruction has been received, Lordship.
Hmm. But affidavit?
It is not filed, Lordship.
So respondent number 1 and 2 had to provide the money required. And they have in fact provided to respond number 3, but it was utilized for some other
No,
purpose.
Lord. The issue was that, Lordship, herein, he was an employee of HPCL,
Mm-hmm.
Hindustan Paper Corporation Limited, Lordship. It went into liquidation, and list was published wherein the claims were admitted.
Mm.
In that first list, my name was missing.
Mm.
They submitted a revised list wherein my name was duly included and the dues were admitted, Lordship.
Mm.
Now, Lordship, the AIDC authorities say that based on the earlier list, we had already disbursed the money.
Mm.
So we do not have any fault. The liquidator says that, yes, we took some time to procure the records, but the dues are admitted. But since I cannot do anything, you approach the AIDC for payment. AIDC says we have already paid, you approach the liquidator for payment. Now, in the tussle between them, even though my dues are admitted, I am stuck.
Oh.
Which is why, Lordship, the Honorable
And
Court-
they are not recognizing the revised list.
they are not recognized. They have released the money based on the original list. The
First
revised
list.
Lordship. And the revised list, my dues have been admitted. The liquidator says that there was some time required to procure the records, which is why my name could not be included in the first list. AIDC says since we have already disbursed, we do not have any money now to again disburse. Therefore, Lordship, the Honorable Court has asked the state that,
So like who are the parties here? Wait.
Lordship,
1 and 2, who is appearing? Mary. Where is that? So 1 and 2, Mr. Chutia, government advocate.
Lordship, can we allow time, further time, Lordship? So far as I think already there are other litigations also, whether this lies here in the REIT or not, Lordship, that also has to be.
So many of the employees had to get money, right?
Yes, Lordship, because it has already gone for the, I think the right forum will be the NCL.
Matters are being sent there.
Yes, Lordship.
no, Lordship.
So you bring some judgments
Yes.
of that, those cases. Exercise, some exercise needs. And you are for respond number
Then you are.
4, the liquidator. And you are?
I'm for 3, AIDC,
Three.
Lordship.
So AIDC. All have filed their affidavits. You also have filed.
Yes, sir.
And you say that they are the valid employees of the corporation and they require.
Admitted to the tune of 1 crore.
Uh-huh.
His claim is, the petitioner's claim is admitted by the liquidator. To the tune
But
of
then the
1
government is saying that they have already released the funds, no more. In view of the first list given. And this provisional list you
What
recognize.
AIDC will say.
This lies with the AIDC, Lordship. I can't remember right now, Lordship. There was a division bench case, Lordship, where some relief has been granted, Lordship, and they were satisfied with some amount which they actually wanted from the government, and accordingly, government has reimbursed this, Lord. That I am aware of, but.
Some employees, few employees were left out.
No, Lordship. Here only one employee, Lordship.
One employee
employee.
only.
Lordship.
Skill basis.
No, Lordship, here the liquidator has admitted that there was some time was additionally required to procure the record. There is no dispute with the admitted claim. There is no dispute with the fact that it is an only for the fact that the liquidator could not furnish my name in the first place. I am ousted, Lordship.
You are the only person left out.
Lordship.
And now they are not,
The AIDC says that we had received the money from the government, but since in the first list your name was not there, therefore we have dispersed it accordingly. So AIDC says you approach the liquidator says you approach the AIDC. That is the stand in their affidavit.
and you are the,
I am.
so you are suffering.
But the tiebreaker would be broken by the government because the money which was given to the AIDC was as a nodal agency to disburse the compensation amount. We have
And
not
this
yet-
was given.
We have dispersed before.
Entire amount is,
Yes, before the name of the petitioner came before the AIDC, it was disbursed. In fact, the official liquidator in the first list, the name was not there. He have gone through a litigation process, then his name was included in the list, which was given subsequently after the money was disbursed.
Acha, there was some litigation before.
He has gone for many, like, he's been fighting from 2001.
No, Lordship, those are.
Okay, then Ms. Bhattacharya, you come up with an affidavit. And you also bring those judgment if it is sent to the NCLT or whatever. Okay, heard Mr. A. Chakraborty, learned counsel for the petitioner, and Mr. Respond number 2, Mr. Decca, no. Three. Mr. D. Decca, learned counsel appearing for respond number 3, and Miss M. Bhattacharya, learned standing counsel for learned senior government advocate, additional for respond number 1 and 2, and Mr. P. Chaudhary, learned counsel for respond number 4. On the last occasion, the learned government advocate took time to get instruction as well as to file affidavit. But when the matter is taken up today, Ms. M. Bhattacharya, learned senior government advocate, submits that the instructions have been received, but the affidavit is yet to be filed and has prayed for some time. Prayer is allowed. List this matter on 1st of June. 1st of June 2026, on which date the learned government advocate may place the affidavit in records with the further instructions. List accordingly. Yes, Mr. G. Das, yes.
It's about regularization of the appointment, Lordship. I was working since.
Acha, they have filed affidavit, matter is ready?
Yes. Lordship.
Yes, okay.
Today it can be disposed of if
Yes,
Lordship wishes.
good. Yes.
It was appointed by the respondent number 3
Ouch.
on 10/3/1991.
No, this is what affidavit in opposition in the
Affidavit of
beginning?
petition, they has filed.
No, you tell me your case.
No.
Petitioner's name is Probindra
Govindra Kumar Das.
Kumar Das.
There are 2 affidavits. One, we have filed one additional affidavit,
Mm.
and they has filed counter affidavit, respondent number 2. Lordship.
You're for respond number 2.
No, your lordship, for 4 and 6. I'm for
You-
2, your lordship.
For 2. Others are not required. Or what? Acha, Ms. Mushahari, that case that the hearing was done. What was the issue? I forgot. The in-charge principle. So I have allowed that petition. Okay. And because it was not his fault that those years have gone by. So I've told the authority to consider his appointment as in charge. You'll get the order today. And I've given a time limit. So consider it within that time. Wait, what is that?
We come to the brief facts of the case, Lordship.
Wait, 1 second. So this case is for appointment,
Regularization of my appointment.
regularization
I'm
of,
working
hmm,
in that post as a grade 4, Lordship.
Hmm.
At Paschim Bonbov High Secondary School, now it is high secondary school.
grade 4 employee in a high secondary school.
High secondary school
Hmm.
in, as a grade 4.
Hmm?
as a grade 4 employee. I was
Hmm.
appointed grade 4, next year one, the appointment letter.
Hmm.
Then thereafter, my service was extended
Hmm.
by up to 31/3/1991.
Hmm.
Thereafter, I received salary also, Lordship,
Hmm.
in that post where I was working.
Hmm.
Then the committee took a resolution
Hmm.
and to appoint me in that post, said post, and was
You
continuing
have
working.
to sit. I'll come
I
to you
was-
when your turn comes. Yes.
I was continuously working since 1991 till this year, 2026, Lordship.
So your appointment was in?
Appointment was on leave vacancy, Lordship.
Huh.
Thereafter, representation also, then I thought it will be regularized. I thought,
Hmm.
I am a layman.
Hmm.
I thought my service will be regularized.
Hmm.
So I was continuing.
Without doing anything.
No, I was in that post only. Then
Hmm.
again after that, I was again in my extra work. Night
Hmm.
secretary also I served.
Hmm.
I rendered my services, thinking I will be satisfied to the authorities. Thereafter, then I didn't receive any salary, Lordship.
Hmm?
Then I did not receive any salary. Only
But you
honorarium.
were receiving salary.
I was receiving for a small amount of time. It is from, I'm coming to that. The petitioner was allowed to raise salaries 31/5/2002 to 31/12/2005. By the
No,
time,
no, you were appointed in 91.
91,
From 91, you were receiving your salary.
nothing. I received only this, on the leave vacancy up to 31/3/91, I received the salary of the Vinod Chandra Boshya against the leave vacancy.
Hmm.
After that, I received nothing.
Acha.
I was working, even though he appeared and he got retired also in that post. I was working. The authorities took my services. I rendered my services there. Thereafter, I approached the principal to regular my salary, to regularize the post and to give my salary.
Where is that?
So there are a lot of applications. I'll come to the repetition. Coming to that. Copy of Annexer 5, page 26.
Hmm.
That's it. But there, the post is originally created, the arrangement is purely temporary and timely without notice. This is the annexer, Lordship. Here I am receiving the salary of Krishna Deka, grade 4 employees of Ganga Pukhuri, Borkuri High School.
Where is it written?
Annexer 6, Lordship.
Annexure 5, not Annexure 5.
Annexer 6,
Annexure 6 what?
Annexer 6. Annexer 6. Disciplinary number 3, Inspector of School, Nalbari District Circle. Order was there also. Here I-
Acha, acha. So you were not appointed to any sanction post?
Not sanctioned.
Leave vacancy.
Leave vacancy. So thinking that I should get the salary, but it was stopped because it was not regular. My GPA was not regular. I have no GPF account, so it was stopped immediately. Salary was stopped after receiving this amount.
Hmm.
Up to 31/12/2020, 2005, it was stopped. After receiving the salary of the other school employee, Krishna Deka, because the inspector has adjusted the salary. Not from this school. Then after what happened, I thought then the title case of the case against the representation,
Hmm.
Annexer 7.
Hmm.
Yes, representation. Annexer 7, page 30 of the petition. It's 30.
This is not your representation. It is forwarded by
Yes. To the
principal, in-class
to the
principal.
inspector of school.
Hmm.
And my application is also there. Application also there. So regarding that, to the inspector, then Annexer 8.
So you were not getting your salaries from 2006.
2006,
Hmm.
yes, 2006.
Till 2006, you got your salaries. I mean, the retired.
Retired, for a short
yes.
period. Because I thought it will be regularized.
Hmm.
No appointment took place in that time. No examination, nothing was done. So now I am serving as a midday meal worker. Till date, nothing has been done. So my humble submission regularized the case of my case of this grade 4 employee. And there's a lot of judgment I've already mentioned in an earlier occasion. Lordship. I have got my judgments. So my case is like that. My
But
case,
you are not against any sanction post.
Lordship. But I was working in that post, Lordship.
Of course, they are utilizing their service. They cannot deny you the salary payment.
Lordship. But only for a short period, from 2002 to 2005. Thereafter salary was stopped. I thought my post would be regular. Representation letter was missing, Lordship. Why only RTA only have come to know? In the 2017, representation letter was missing, Lordship.
And what is your additional affidavit?
Yes, sir. Only petition affidavit I have given the
RTI.
Yes, RTI. So by RTI only I come to know that representation was missing, Lordship.
This is your representation.
Yes, Lordship. Whenever because the respondent did not take any step against to stabilize my post, Lordship.
There were
Neither
many
in
representatives.
examination, neither in examination, nothing. So they has filed their affidavit. In there's respondent to has filed their affidavit.
Respond number?
2, the director of secondary education. Yes. They are not denying the fact. They are admitting everything in the petition also.
Ouch. Where is their affidavit? Yes.
Affidavit also.
Affidavit by respond number 2.
Respond number 2.
You are there, Terangpi, you are there.
They have admitted everything.
What do they say?
I'm read down the affidavit.
Yes, Ms. Terangpi, what do you say?
Lordship, in here, the petitioner is on leave vacancy, Your Lordship, and later on his service has been extended, Your Lordship. And later on, the SMC took a resolutions and has appointed him, Your Lordship.
Took a resolution what?
Took a, on Lordship in page number 51, Your Lordship.
51, yes.
He's been appointed on honorary basis, Your Lordship.
But make me clear, what is that leave vacancy? Somebody is on leave.
Yes, Your Lordship.
And his salary was paid to him.
He paid
Yes,
to
Lordship.
him, Your Lordship.
Binod Chandra Bosha was on leave.
Yes, Your Lordship. On that base, he's been appointed, Your Lordship.
He
And
has
then-
been in leave throughout.
So the work has to be done by someone else, Lordship.
So they has taken my services
That is
and
what-
they have given the salary also.
So the
and
managing
other
committee took a resolution to appoint petitioner on honorary
Honorary
basis to
Yes,
act
sir.
as grade 4. And the then headmaster issued appointment letter in 92. In the meantime, was allowed to
Appointment
draw
has
his
been issued by
salaries.
The headmaster, Your Lordship.
Huh?
The appointment has been issued by the
By the
headmaster.
headmaster. And the petitioner was allowed to draw his salaries from 2002 against a retired vacancy, from leave vacancy to retired
Retired
vacancy.
vacancy.
What happened to that vacancy? Leave vacancy? No knowledge.
Knowledge, Your Lordship, regarding-
Acha, 1K. And he received it till 2005.
That's-
So till 2002, he received the salary on the leave of the person who was on leave.
Leave, Your Lordship.
So what they say is that the inspector of schools have allowed you to draw the salary of that retired. That was also rehearsed the rules. That was also not according to the rules. So you were appointed on an honorary basis.
That's it.
You had taken salary of the leave of the person who was on leave.
That's it.
From 2002, you had taken the salary of the person who had retired till
2005, December,
2005. After 2005, you have not got anything.
nothing.
After 2005. But they are utilizing your services. So when you are utilizing his services, you have to pay. You have not terminated him.
Solution has been taken by the SMC, Your Lordship. So in this regard, Lordship, I will not be able to give any reply.
Who is appearing for? She? Who resolution is taken by whom?
SMC, Your Lordship, the school managing committee.
So you represent managing committee? Okay, what do you have to say?
Your Lordship, there was no valid selection process. He was working voluntarily.
But there are judgments saying that when government utilizes the service, they have to pay. On that, what do you say? Okay, he was not appointed, he was appointed on honorary basis or leave vacancy, whatever. And then he has been working since then till today, right?
January.
Then you cannot deny him the basic human rights, the basic salary.
Yes, Your Lordship, but he was working voluntarily. No one appointed him.
The principal of the school appointed him. And the principal, the inspector of schools have also recommended his representations. Any case law on this?
Yes, Lordship, lot of
Acha, I'll come back in 2 minutes time. You make ready, keep ready the case laws.
Lordship.
I'll dispose of this.
Because I was working in that post. Government post also. They are taking my service.
Regularization, how can you bank
Other
upon?
salary, Lordship. Other full salary since 2000.
That I can give you. Regularization, Uma Devi is there unless it is.
My Devi's case.
Hmm.
Jagu's case is there. My case is a bit more than Jagu's case. Because I have served more than 30 years. Jagu is 10 years. So I've got my judgment also.
Yes, give me.
Your Lordship, I would like to draw your attention to page number 11, para 13.
Okay, let her no, I have not finished with him. I'll come back to you.
Another
Yes.
case, latest case. Jahangir Laskar was set of West Bengal. Another
This is Jago.
Jagu and Uma Devi's case is also there.
Hmm. So Jago, which paragraph?
Another judgment. Jagu is paragraph 10.
10.
10, paragraph 10. I've already highlighted it.
Okay. Paragraph 10 only?
10, 11, 12. And and
So here what happened? Service was regularized.
that's it. It was regularized. And another case I am citing Jahangir Laskar was state of West Bengal.
Wait, let me see the last paragraph. Services regularized forthwith. Then this one,
Then another case.
Kohima bench.
Yes, Lordship. There also, this is also regularized. Uma Devi's case will be reflected in this case.
Hmm. Which paragraph?
Everything first, second. I have not.
There the post was a sanction post.
Lordship,
Kohima case.
Lordship.
Hmm.
Then another case, Mohammed Jahangir Laskar, versus State of West Bengal. 18 March 2026, latest case. So I'm placing this before this Lordship. Paragraph, I'm placing before this. It is similar to my case. This is that, right?
Hmm.
It's in 19 paragraph. It is similar to my case. The latest case. Paragraph 19.
Paragraph?
19. 19 and 22 lots. It is just like similar to my case.
Hmm. 19 and paragraph?
22 Lordship.
Irregular and
Irregular
illegal
and
appointment.
irregular and
In this case, it is not illegal appointment at all.
illegal. Because there is not hold any interview in the vacancy
Hmm.
post. Till date. And recently I heard that that post has been.
But again, it's a sanctioned post.
Lordship.
Yours is not a sanctioned.
Not sanctioned, it is not sanctioned, that is the problem, because representation was carried out, but it was not sanctioned, I thought it will be sanctioned afterwards. 2017 I was waiting, since 2017 I was waiting.
Show me a case where the post is not sanctioned. But salary is allowed. Amanda. Oh, no. No, pet to Nana. Assess. Bring some judgments on non-sanctioned post.
Chief, this case only says about this sanctioned and non-sanctioned post, Lordship.
Where? Give me that.
Para 20, Lordship. Then 21 also, and 26 also. Telling this only, because it was also appointed by the resolution of the managing committee of the school.
Give me that.
Para 21, petitioner was engaged by.
Which one?
Jahangir, the Mohammed Jahangir Loscar.
So you have not given.
I've given lots.
Where?
21 pair. I've given. Just now I'm giving.
Oh, yes, Jahangir
Jahangir
Loscar.
Loscar also. The latest case.
Where? I don't find non-sanctioned part
21.
here.
Mohammed Jahangir Loscar.
Paragraph?
Paragraph 21. Mohammed Jahangir Loscar, State of West Bengal.
Hmm.
I'm read out. In the opinion of this court, the circumstances of the present case do not indicate any backdoor entry or clandestine appointment. The petitioner was engaged by a resolution of the managing committee of the school to meet an immediate academic.
Later on, it was sanctioned.
Later on section also. So my also case it was sanctioned. It could be sanctioned. Had it been the representation part had been over. 2017 representation was sent to them. But that letter has been missing out. The process gonna stop, the process gonna start.
Acha, what I can do is not regularization because it's not sanctioned.
Acha.
You make appropriate application, representation to the appropriate authority and they will consider, I'll write all the requirements. But consideration only.
Acha.
Either to make your post a sanctioned post, payment of salaries, of course, they have to give because they have
Salary-
to utilize. Regularization, I'll not give, I'll leave it to them.
Let's,
Okay?
let's,
Heard, Mr.
G does.
G Das, learned counsel for the petitioner. And Miss H Terangpi, learned counsel for respond number 2. No, 2 and 3. Yeah, you wanted to say something. What? Which page?
Page 11, your lordship.
11 of the writ petition.
Yes.
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 Hmm?
Page 11, para 13.
13.
Yes.
Hmm.
Yes, your lordship.
Yes. What do you want to show from there?
Your lordship, he was merely assuming that one day his post would become regular.
Hmm.
So, on mere assumption, he was rendering his services without any valid selection process. So, this is
You cannot bring those strict requirements in this case. He is a poor person. He was working as what? He was
Fourth grade.
working as a
Okay, yeah.
4th grade employee. And he had also made his representation. Representation was lost. It was forwarded by some authority, by the principal to the inspector,
yes.
inspector of schools. But the school has utilized his service. In those facts, things cannot be so inhuman. Right. So let the authority consider his otherwise payment they have to give since that 2025, 2005, 25 or 5.
2005, December.
Lordship, one.
The basic pay at least.
Yes, Lordship, here I'm appearing for the treasury officer. We have a very limited role.
Hmm.
But Lordship, here my learned friend is silent on the part. Since 2006, they have not received the salary.
Hmm.
In 24, they are filing the petition
He
claiming.
was under a genuine
Lordship,
assumption.
Lordship, now that there are judgments
Hmm.
where area salary for 3 years can be granted. Here, Lordship, it's not, I am only appealing for it, but there are plethora of judgments where they're saying that 3 years may be counted. If they're claiming salary for a period for more than 3 years, then the petitioner has to satisfy your Lordship. Here on the mere assumption, my learned friend is saying for 10 years he has not been paid. What was the reason why he did not appear? That he has to come with. Now he's coming out of, and all the appointments, all the people that my learned friend has been, the petitioner has been working for, as school level managing committee does not, for regularization, Lordship, that does not make him a government employee.
Hmm.
He is, here he has written, Lordship, if I may, out of love and respect for the students, he has been working. So whether that makes him entitled for salary, Lordship,
No.
that part, since they are utilizing, let the authorities verify his service record, Lordship has, but regularization, he has not even come under the government domain.
Yes, so regulation, I'm
Yes.
not ordering anything.
No, and here he's coming, asking for 20 years, Lordship, salary of about, because is he still working? Is the
No, he's left, January, after January.
January of 25?
He is now working as a midday meal. Lordship.
Yes,
There's
Lordship.
midday meal.
So for
He is
20
getting only
years,
15
He's no
hours.
longer in that school.
No, he's in that school, but midday meal program is now a cook. Because that position filled up. In the post he was working for last 20 years.
That retired person.
Yes, now it is filled up. 14 days is petition going on.
So he's working in the midday meal.
Midday meal as a cook, he is getting only 1,500.
that is,
Let the authorities
Yes,
verify your services
Lordship.
let
rendered.
him verify.
Yes, and
Let him
since
pass a speaking order, Lordship, regarding his representation.
And
But he's claiming 20
and
years of salary.
representation was given by you on what date? 17.
2017, Lordship.
That's it, Lordship.
2017.
That is what, Lordship, that
Management
20 years of salary they are asking for, Lordship, there is some bar, because they could have approached the court earlier also. Lordship, not saying that, yes, they have also their own difficulties, but 20 years of arrears salary has to be verified by the authorities, Lordship. Till
Let
date.
it be verified. I'll place the facts and all. Okay.
Lordship, my humble submission is that I was waiting for the reply of the representation since 2017. At that time, I don't want to spoil my career, I don't want to spoil my image, filing a petition against the school authorities. There's a clear reason because.
Now he's ready.
No. Thing is that he is saying, why you have not filed a case?
Yes.
I have to misguided, they have misguided me that one day you're supposed to be regularized. For that reason, I have not filed any case against the authorities.
It's okay.
Now after
That
20
is-
years, Lordship, I'm just
And
pointing
is
it out.
it is
Just
not-
pointing it out.
No.
No, it's
No
okay. It's
limitation
don't
is
don't
there
get
also.
angry. It's okay. I'll pass the order. Okay, heard Mr. G. Das.
G. Das.
G. Das, learned counsel for the petitioner, and Mr. Ibrahim Ambudidwa. Actually have Terang P. And your name is?
Shelly Chakrabarti, appearing for Soradip Day.
Okay, whatever, huh? Busy person. Okay. The petitioner's case is that by this application under Article 226 of the Constitution of India, the petitioner has prayed and prayed that the respondent number 2, that is the Director of Secondary Education Assam, be directed to sanction the grade 4 post and or to hold selection process to accommodate the petitioner. Full stop. The case of the petitioner is that he was offered a temporary appointment, right? Okay, he was appointed temporarily in a grade 4 post in Poshtim Bonbhag High School in the scale of pay of 900 to 1435 per month plus other allowances. Against a leave vacancy, and his appointment was made effective from 1/3/91 to 31/3/91. The petitioner also states that his appointment was extended from time to time and by order dated 19th of April 91, the petitioner who was appointed the said vacancy is allowed to continue as grade 4 employee in the same school full stop. Thereafter, a resolution was passed by the executive committee of the said school by the committee of the school, whereby it was decided to request the authority concerned for sanctioning a post of grade 4 employee. Sanctioning a post in the grade 4 along with one post of night chowkidar. Thereafter, on 13th of June 1994, the principal of the said school appointed the petitioner against an honorary post and it was also stated in the said letter that petitioner who has been working since 1/6/1991 would continue to work from that day. The said, oh yeah, the proposal, no? Thereafter, on 13th of June 1994, the inspector of school by a communication to the director of secondary education sent a proposal for sanctioning one grade 4 post in the school. It was further stipulated in the said letter that since the school has been newly provincialized, only 3 grade 4 posts has been sanctioned and that another grade 4 post may also be sanctioned for the interest of the school. The petitioner has stated that since his appointment in the year 1991, till the year of 2002, he was paid the salary against the leave vacancy, right? Against the leave vacancy. And that by order dated 6th of September 2004, the petitioner was appointed. No. 6th of September 2004, the petitioner who was appointed, likha thik hai? The petitioner who was appointed on an honorary basis in the said school was allowed to draw his salary against the retired vacancy and the monthly salary was paid to him as such. The petitioner thereafter states that he was drawing his salary from 2002 to 2005 against the retired vacancy. But after 2005, he did not get any salary. Accordingly, he made a representation to the inspector of schools on 9/3/2025. You have made your representation also after 10 years.
No, not sir.
It is there in your additional affidavit? Or before also you have made?
Yes, sir. A lot of applications I have.
2017 likha ho.
2017.
It's
2017.
2017, huh? He had made various representations. Before the inspector of schools? from 2017 onwards. Praying for payment of salary as well as to make his post sanction for payment of his salary as well as to sanction his post in the said school. In pursuance to these said representations, the inspector of school, oh no, wait, yes, Ellen? Where was the forwarding by inspector of schools? Hmm. Hmm.
Annexure 7 and Annexure 8. Annexure 8 and Annexure 7 also.
No, this is by him to inspector. Inspector of schools had forwarded his representation. No, it is not forwarded.
Process has been not.
Oh, it's the principal had forwarded.
Principal according to the inspector.
Acha. He also made representation to the inspector.
Yes. To the inspector. The inspector had to initiate the process for the director. He has missed that, he has missing.
No, wait. He may, in your additional affidavit, you see, he had made representation to the inspector of schools.
3694, the different vector state that I am coming to the page 37, the inspector Nalbari.
To inspector of schools. Acha, Acha, wait.
Para 4 of my additional affidavit.
No, I'm seeing the annexures. And it is also stated that the principal of the said school had forwarded the representation, forwarded the representation to the inspector of schools, Nalbari, wherein it was stated, wherein after stating the facts narrated above, a request was made by the principal for payment of his salaries since 1/1/2006. With a further statement that grade 4 post was lying vacant due to retirement of the erstwhile employee. The learned counsel for the petitioner submits that the petitioner was under the constant belief that his services, belief that since his services was utilized in the school, he will be paid regular salary and his services will be regularized. He also submitted that the appointment of the petitioner can be termed as irregular but not illegal. And he has been continuing since the day of his appointment, since the day of his temporary appointment, till date. First few years on receiving, till date, first few years on receiving the salary against the leave vacancy, and few years thereafter on the salaries against the retired vacancy. As such, a prayer is made for payment of his salary as well as regularization of his service. Ms. P. H. Terangpi, learned counsel for the respondent, for the, for secondary education, right? For the second, learned standing counsel for secondary education department submits Ouch. That the petitioner was appointed against a leave vacancy and his services was extended from time to time. And that that later, the managing committee of the school took a decision to appoint the petitioner on honorary basis, and the headmaster had issued the appointment letter. And that in the meantime, the petitioner was allowed to draw his salary against a retired vacancy, and that he received the same till 2005. She further states that that right of the petitioner for accommodating him against grade 4 post would only accrue through a valid selection process, which was not undergone in the instant case. Miss Parakurba, huh? Miss, your name please?
Shaili Chakrabarti.
Shailin Chakraborty. Appearing on behalf of respondent number
4 and 6.
4 and 6 submits that the petitioner was not appointed against any sanction post and that he is voluntarily working as grade 4 employee in the said school. And as such, he has no rights for the regularization of his services, as the post was never sanctioned, as the post was not a sanctioned post. Mr. Choliha, write your argument or not? Yes.
20 years of salary is
Okay. Yes. It is seen.
The principal and school managing committee, they have not the authority to government employment lordship. School managing committee consists of the principal, the local parents, and the local authorities. So the case of the petitioner for regularization, I'm opposing to that.
Yes, yes. That of course, without be a sanctioned post, it's difficult. It is seen that the petitioner has been temporarily appointed in the year 1991 and his services were utilized in one post or the in grade 4 post till the said date, and the petitioner is stated to have been working till December 2025 as grade 4 employee. It is the case of the petitioner that after that since January 2026, he is working in the same school as a cook for the midday meal
program.
provided to the students. It is as such seen that he has never left the school and he had offered his services for the smooth running of the same. It is also seen that the petitioner had received his salaries against the leave vacancy initially, and then against the retired vacancy from 2002 to 2005. And after 2005, he had not received any salaries. Tumake dighol bur pai asa no? 2000 so and so. But he had made representations to the authorities concerned for regularizing his service, as well as to pay his salary. And it is also seen that the principal of the said school had forwarded the case of the petitioner to the inspector of schools for consideration. Oh, হেৰি তাত নহয় এওঁতাত এই জাজমেন্ট দুটা লিখি দিবা হা To substantiate his argument, Mr. Das has relied on these two judgments লিখিলো এনে লিখি দিলে হ'ল দুটা okay yeah It is no longer res integra that if a service is utilized by the authority concerned, even without a sanction post, the payment, the salaries, or the basic salary, that is the payment, has to be made to the employee concerned. Non-payment is considered to be unconstitutional and in violation of the fundamental rights. Particularly, if the employee is made to work for a long period of time. In the instant case, the petitioner is made to work since the year 1991. Now it has been how many years? 2001.
35 years.
35 years.
Yes, Lordship. My whole life gone wasted.
In the instant case, the petitioner has worked for almost 35 years in service to the school. As such, his payment cannot be denied. Although it is seen that the petitioner, after almost 2005, 15, 24, when did you file this petition? 24.
24, Lordship.
4. Although it is seen that the petitioner has filed the instant petition after a period of 19 years.
So 17, I was thinking it will happen. From 17, I thought, because I was a very sport gate. Whenever a principal
Okay,
says,
19 years. But it is also seen that he had made his representation in the intervening period. And being a grade 4 employee, he was under the impression that the authorities would regularize his service and give him the salaries. It is as such directed that the authorities in the secondary education department would consider the case of the petitioner There is no reply from the inspector of schools?
No.
No. Full stop. It is also seen that the principal had written letter to the inspector of schools forwarding the case of the petitioner, but the inspector of schools had not replied to the same. Full stop. And in the forwarding report, a request was also made to sanction one more post in the grade 4 employee. But then those posts are filled up. But anyways, they will consider. Grade 4 post And the petitioner having worked since long in the grade 4 post, a legitimate expectation is built up in respect of the petitioner. In view of the same, this court directs the authorities in the secondary education department to consider the case on a representation being made by the petitioner afresh. The petitioner is directed to make the representation before the said authority along with a copy of this order, and the authorities to consider his case within a period of 1 month from the receipt of this order. Eta line report likhi diba sir before this sir. Although the petitioner is no longer in grade 4 post, cook is not a post, grade 4 post, and is working as a cook in the said school. His case should be considered. See, and since he has worked in the grade 4 post for long,
35 years.
35 years. Okay. Petition is disposed of. Regularization thing, I have not said anything. It is for the authorities to. Okay. Econo diba hoy. These 3 judgments, huh? 18 ta likhi diba. Let these judgments be here. This was.
My lord, in this matter,
Mm.
I think I'll have to take a instruction regarding the reconstruction of the service book. He is getting his pension, but there is a difference of that amount, my lord. So that is
Achha.
what he's seeking. So his service book are not available. So AG has returned to the PWD. So I will take the instruction whether that PWD has done it or not, my lord, whether they have
As
that-
far as reconstruction of his service
service
book you
book,
want.
yes,
some
and then
instruction.
this will be forwarded to the AG.
Okay. 1 week's time?
10 days, my lord. 10
10
days.
days.
Of course, my lord, this week,
All busy in
all busy, my lord.
celebration.
Very
Achha.
difficult, my lord.
Uh-huh.
We are waiting for a date to be fixed.
Heard Mr.
H. Budaguhai.
Hmm?
H. Budaguhai.
H. Buragohai, learned counsel for the petitioner, and R. Dhar, learned standing counsel for
PWD.
PWD. Mr. Dhar submits that he requires some further instruction with regard to the reconstruction of the service book of the petitioner and has prayed for some time. Prayer is allowed. Lays this matter on today's 13th, 28th, 29th of May,
My lord.
2026.
Lordship, in item 12, Lordship,
Please, Lord.
Yes.
I am supposed to file one affidavit, Lordship.
Pass over the matter for time being.
Yeah, she's,
In
let me
Lordship, kindly allow me
hear.
1 week time, Lordship. Next week it can be listed.
Okay. So next week she'll file affidavit. So Miss M. Bhattacharjee, learned government advocate,
Appearing
respondent
1 and
number.
3.
Yes,
Appearing for 1 and 3, Lord.
for respondent number 1 and 3 submits that she requires further time to file her affidavit in opposition. The prayer is allowed. You are appearing? You have filed your affidavit? Mr. R. Sharma on behalf of Adhar is present and has stated that the affidavit has been filed. List this matter on what date, Ms. Bhattacharya?
Any day after 20, Lordship.
List this matter on 1st of June,
Okay, Lordship.
1st of June, 2026.
Nipple.
13. What needs to be done?
My lord, this matter is for computation of gratuity.
Computation of
Gratuity.
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 Hmm.
So the petitioners, my lord,
What happened to this side?
the Assam Gramin Vikas Bank needs to be represented, but more
Huh.
importantly, my lord, if I
And central government is also a
central
party?
government is also a party, my lord. If I
Not a,
no, they are the actual party, the necessary parties here. The reason being that this honorable court is not the first forum of adjudication of in matters of gratuity.
Hmm.
It has to first go before the controlling authority, which is the first line of adjudication in the matter. Thereafter, the matter goes to the appellate authority. And thereafter, my lord, this honorable court has jurisdiction to try the matter. Now, the matter has gone through all of those stages. Now, the last order, my lord, which we have challenged in this writ petition, your lordship would find that order from page 156 onwards.
But then without their representation, it will be difficult for me to
Ideally,
dispose.
my lord, the labor commissioner ought to be here.
So who appears for him? You contact that person and
Central
let me know. Central Minister
CGC should ideally appear, my lord.
SK Mehdi, you are there?
RDB was there, my lord. I'll inform.
RDB was in some bereavement. I think yesterday some prayer was made. Or she was busy in brother's
Yes,
treatment.
Maybe, man. So, maybe come after 2 weeks, my lord.
RDB is not there.
Hello.
Yes, Kali kusle no? Brother's treatment in Kolkata or somewhere?
Yes, my lord, yes.
So let RDB come, we will hear.
Ideally, the matter has been dealt with by the division bench of the Madhya Pradesh High Court, which has been subsequently upheld by the Honorable Supreme Court.
Mm.
So what happens is, my lord, in the case at hand,
Mm.
the Assam Gramin Vikas Bank has a service regulation. Now, Assam Gramin Vikas Bank is a statute of the Rural Banks Act.
Mm.
Now, all the states have a perimeteria service regulations pertaining to their respective banks, my lord.
Mm.
So that issue has been laid to rest by the Honorable Supreme Court, read with the honor of the judgment of the learned division bench of the MP High Court. But since RDB is not here, my lord would kindly like to fix a date for this matter, my lord, because they're all retirees. And
Yeah, I'll fix it.
I'll fix a date. Subject to your
I'll
lordship.
fix a date.
After
And if by that time she cannot appear, then Mr. SK Mehdi, you please appear.
my lord, right.
Look into the matter.
Because
Hmm?
I have the materials at hand to substantiate my case, but as in
The person had retired.
all the people, all the individuals are retired. So the dispute was that I am entitled to, I prayed for a gratuity. They gave me a sum, which to my understanding was not fit and was not right, pursuant to the formula which has been laid down. I approached the controlling officer. The controlling officer gave a verdict which was in my favor, which was completely overturned.
Okay, okay. We will hear it on
After
that
2 weeks,
day.
my lord, she will be there, my lord. After 2 weeks, my lord. Immediate, my lord.
Yes, heard Mr.
M. Sharma.
M. Sharma, Learned Counsel for Petitioner. It is seen from the orders that Miss R. Devi, right?
Yes, my lord.
Miss R. Devi, Learned CGC,
CGC.
is handling the matter, which is also stated by the Learned Counsel for Union of India. And it is also, full stop. It is further stated that Ms. R. Devi has some personal difficulty in appearing in the matter today. As such, time is sought for. Prayer is allowed.
2 weeks, also.
List this matter on 3rd of June. Wednesday, yes, 3rd of June, 2026. On which date, if the Learned Counsel for the Union of India is unable to present herself, then another counsel, another CGC would appear. An endeavor will be made to dispose of the matter. That wasn't it? Wait. Sandal Pinoni. Wait, 1 second. I have the habit of removing my sandal. Okay. Hello. Matters, right?
Yes. That's a good.
Yes, Mr. Day.
Have a small prayer. So far, item 20 is concerned.
20.
Yes, my lord.
Just a second. Where is
The pleadings are complete.
wait. I don't have my specs here. Yes, item 20.
20, my lord. Pleadings are complete, my lord.
Okay.
So, but can it be fixed on a, my lord, on a hearing date, my lord, so
Okay.
that, my lord, matter can be.
Subject to what Mr. SK Mehdi
Yes,
says.
my lord, we are.
Yes, my lord. I'm searching the date, my lord.
Uh-huh.
I'm searching one date, my lord.
Okay. Searching a date now. Acha, okay. So, on the prayer made by Mr. R. Day and which is not objected to by the learned CGC. List this matter again on. You have not finished searching. Yeah, list again on
Any of the July.
8th of June, July.
The termination of service, my lord. So, my lord, that's
So-
the urgency.
He is not working anywhere now.
No.
So 8th of June,
25th of June, madam.
25th of
June, madam.
June. Such a long time.
Otherwise,
You
madam,
take a date before that. 10th of June. You'll not be here or what?
10th of June, I'm here, madam.
Huh?
But it is Wednesday, madam.
What?
Okay,
10th of June.
10th of June.
If something happens, we'll accommodate again.
Yes, 10th.
But this is for which year? Oh, 25, it's okay. 10th of June.
10th.
If you cannot appear, let me know. We will again do.
Yes, 10th of June.
Yes.
My name may record. madam.
Huh. Mr. S.K. Medi, learned CGC is present.
Lordship, with respect to item number 92 and 93,
Hmm.
bail matters, Lordship,
Hmm.
KK Parasar was supposed to go through it, Lordship, and he has already conducted the hearing.
Hmm.
Today, Lordship is unavailable, Lordship, because his uncle had died.
Hmm.
So I have already talked with the counsel appearing for the petitioner, so can it be fixed on Monday, Lordship, next month?
Okay, but then yesterday Mr. KK Parashar had seen the records and have told me the required things.
Yes.
So I thought I can dispose it of today. What about Mr. H.R. Chaudhary?
Sir, lagging on court number 14, he said that time being corrected.
Time being. It's okay. I think he has already, only one point was required to be seen, whether he was medically examined after the arrest.
Yes.
So KK Parashar had seen the records and said that he was medically examined even on the day of his arrest.
Yes.
So matter is settled there. Right.
So I'll ask somebody to be present here,
Huh.
Lordship.
Anyone can be present.
Lordship,
Okay. You tell Mr. H.R. Chaudhary to come.
Lordship.
Now.
No, not now, when the matter reaches. Mrs. Sakia, yes, 53. This is not the same matter.
Regarding medical leave, you have also earlier heard the matter.
Acha, acha. Oh, 52 you said, yes, at 2 o'clock. Yeah. 53.
The child, my lord, is a subject to mathematics in Anderson.
You are ready? Records are there?
Yes.
Records were supposed to be placed?
Please by the principal, your lordship.
Huh?
It was
Respondent number 5 was directed.
Already filed an application.
If you're fine.
In hearing, I am appearing for respondent of file the principal. He has joined the.
Okay, you are ready with the facts, right?
I have no objection. Every hard leave application, everything has been forwarded by my predecessor to the departmental authority. Now it is up to the authority to regularize her leave and to make payment.
Who is the authority?
Here,
My lord, leave will be sanctioned by director, I think director of education,
inspector of schools.
inspector of schools.
So inspector of school is made a party?
Yes, yes.
Who is representing?
Actually, he will be forwarding, since it is a long leave, the director is the sanctioning authority.
Mm-hmm.
Director is the sanctioning authority, inspector is the forwarding authority. I can say
Gotcha.
forward. Since it is a long leave, my lord, otherwise, my lord, inspector would have. He has partly sanctioned the leave. But my lord, the later on, it has become, my lord, 6 years, because he has undergone three heart operation.
Yeah, I remember.
Yes, now since 2012, he is presently working with medical treatment and all of that.
So inspector of school has recommended for regularizing the leave.
Yes.
Now it is for the director to,
I'm sorry to interrupt you.
you have to fold hands for this. Folding hands is only before God. Yes.
Only thing is that everything has been forwarded to the departmental authority. Inspector of schools will forwarded with to the director, and upon examination, they will regularize and make payment. It is up to them to regularize the leave.
But why are they taking so long? When was the
forwarded? The school has already forwarded.
respondent number 5? You are for the school.
Yes.
You inspector. So he has no more role to play. Only that Miss H. Terampi has to say why it has not been done so till date. No, instructions I have already given a lot of time.
I am also having sympathy with the petition.
Huh?
So he has
A lot.
undergone 3 heart operations.
So, okay, I'll give a, within a stipulated time, he has to consider the representation of the petitioner along with the forwarding report. That will do. That will do, Ms. Sakya.
Last time your lordship was supposed to pass the order directing my lord that to regularize the leave and 50% salary along with. And some adverse remark was there, two adverse remark is there, that he is on leave without any, he is absent without any, my lord, application. That is the false application.
But according to your applications were submitted, were given.
Yes.
Okay, I can dispose of this matter today.
It can be disposed of, let the authority examine and do the.
Again, it will be left to the authority.
Yes.
But she doesn't want to be left to the authority.
Ultimately, this court cannot decide the fact,
Hmm.
Your Lordship. Have to be decided by the department.
So I'll write the judgment in such a way that they will consider it soon as possible. And because there is already a forwarding letter by the
Pursuant. They, tell my lord, handicapped person like, he is teaching mathematics, he has got very good reputation, specialized.
he can also submit online.
So he cannot come in the pursue, your lordship, no the government officers, unless some pursue my lord, personally coming pursue my lord.
Can it not be done by online method?
No, my lord. Online, whatever your lordship will submit, nothing is recorded.
Already
If-
Already
So,
all
your lordship,
relevant
even-
records are there with the department of law.
Huh?
A direction may be
Your
given
lordship
within a
pass an order,
specific
my lord.
period.
Considering the.
Acha, let me see the case. What is the,
Facts
if,
and circumstances. So
if
the-
direct directions can be given, okay, we will see. I forgot the facts. Petitioner's name is Niloy Dutta. So petitioner was working as what?
Subject is in mathematics.
Okay. 94 he was appointed.
94 he was appointed and his service was regularized my lord on 30th of August.
2001.
2001.
And then he went on leave.
He is, my lord, 80 days leave was regularized my lord in Annex 3, page 23.
80 days period.
80 days.
On leave for a period of 20 days.
Yes.
20 days. Right. I heard 80 days.
Next.
For treatment of his hurts for his surgery, heart
Deputy
surgery.
my lord, extra for 80.
So 35 days was
Page
sanctioned.
26, my lord, it is 80 days.
Page?
Mine leave, page 26.
Hmm.
the period of
This was
80
after
days.
expiry of this.
Yes.
3/6/2008, 7/6/2008.
Some of the leave was granted.
No, what is the difference between page 23 and 26?
23, my lord. Initially, a portion is my lord regularized, see the date, my lord, there. It is from hereby granted on memo number so and so, 8/3/2005. 35 days.
Ah,
Again, my
35
lord,
days.
Yes, again, my lord, page 26, it is
Hmm.
dated 15/3/2006 to 18/4/2006, 35 days.
Hmm.
Then, my lord, page 26 is.
No, no, 14 days. Then
Period
again,
is 19
7 days. So where is this 80 days, a period of 80 days with effect from 1/3/2006?
14/3/2006, 14 days. Again, my lord, 7 days,
Hmm.
56 days.
Hmm. Okay.
Calculate that is 80 days.
This is by inspector of schools?
Yes, ma'am. Only.
What's,
That was earned
on leave on MC, medical?
Yes, ma'am.
MC means?
Medical.
Medical what?
Yes. On MC. Exactly.
This leave of 80 days was granted.
Yes, my lord.
Then
Sanction, my lord, it was. So he received the payment probably. Thereafter, my lord, page 33,
page 33 is what?
page 30, my lord, sorry, page 30. That is the, my lord, initially,
This is the discharge summary.
page 28 first.
Hmm.
Page 28, annexure 5, He was initially, while he was in school, my lord, he got the heart attack.
Hmm.
What is rheumatic attack or heart attack it is? Thereafter, my lord, is admitted to Silchar Medical College,
Hmm.
hospital. Thereafter, they referred my lord. There he remained 2 months, my lord, that page 30,
Then he was discharged.
he was discharged.
Discharged on what date? To 12 April 2006.
9 March 2006.
No,
He was
12
admitted-
April. Discharged on.
He was admitted on 1st of March 2006.
Page 30 you are reading?
Page 28.
Or 28. Yes. Okay, he was admitted.
On 1st of March 2006.
Hmm.
Discharged on 9th of March.
So 9 days, 8 days.
Yes, ma'am.
Then again,
Then again.
27th of March, 12th of April.
Yes,
Then,
they have referred him to Christian Medical College, Vellore, for operation.
hmm.
There, my lord. Discharged on 12 April 2006. From 27 March to
So which is the leave period that was not accounted for? Which is that leave period?
which is the leave period, my lord. Continuously from there, he could not join, my lord. Continuously could not join, but my lord,
I have stated in para 5 of my affidavit, everything details are there.
No, initial period he had the leave.
Yes,
He was permitted.
service book is there. Initially, he was on leave.
Ah,
Service book is there in the restriction. Silence C.
paragraph
He also said
87.
that.
Yes. Hmm.
So I have highlighted in my affidavit also.
Hmm.
Only on medical term for period of 80 days
Hmm.
from the services.
This I have seen.
So,
And leave on duty. Ah, but the teacher concerned.
Again, 11106,
Hmm.
51107.
Hmm.
In fact, thereafter till 2012.
The teacher concerned was absent from school from
I'm not
111.
concerned about the earlier period, from
Huh.
1/11/2006, he was absent till 3/9/2012.
Hmm.
About
About 12, 10 years,
yes,
6
about
years. Stands released from
12
school.
years.
he was sanctioned up to.
And he was released from school on 3rd September 2012
Yes, my lord.
in the
from another
afternoon.
school.
in
And his
pursuance to
school
the
was-
order.
It's
So
not-
he is not working now.
Working, he's working. Honorable court was pleased to pass an order to put him in a nearby school.
Acha, acha.
So he was transferred and my lord, put in other one.
So he's challenged his release.
Salary he is getting regular.
No, no,
salary.
he challenged his release.
No,
No, no.
he
That
is
is not.
praying for regularization of our
Leave.
leave periods.
And
the
increment he has
payment
not
of
received
leave.
any.
No, but then what does it say? He is released from school.
That is
See the
definitely
third,
Enable him to join in a new, another school.
oh,
Yes,
another
sir.
school.
Nearby
Another school,
Nearby school.
nearby school.
Where is that? This is not reflected here.
All right.
Stands released from school on 3rd September 2012 in the afternoon
Yes,
in pursuance to the order dated
page number 98, huh?
page number 98. Hmm.
Order is in compliance of the High Court order dated so and so. Passed in so and so.
In his own grade, he says he's transferred and posted at Adharchand High School. This was 29th of November 2018.
18.
29th of November.
He's still working, my lord. But he's not receiving the increment since 2006. And his leave period has to be regularized or whatever he gets, my lord. And Third prayer is, my lord, expanse of the adverse remark.
Where is that adverse remark? This one.
Adverse remark in the service book, my lord.
Hmm.
In page 87. Page 87. The teacher concerned.
Oh, yes, this is what we have just seen. Hmm. This is the adverse remark.
Yes, my lord, without any, has been
Without
absent
any
from school.
intimation,
Without
that's
any
why adverse
intimation.
remark.
He has intimated, so my lord, it is both the remarks are adverse
matter-
because without intimation, no, he has intimation, he has taken for leave application.
Matter request to be examined by the authority and there the authority is to verify the records and do the needful.
The representations were already filed.
So many,
No heat,
no, my lord, no disposal, no order,
no reply.
no reply. It should also let us disagree.
What are these other documents for? Not relevant.
My lord, representation, I have only one annex, my lord, that is in page 99. To the principal again, they have written.
Hmm.
From this man. By 22. There, before that, my lord, he has filed for medical leave application, but other applications are there still. So many applications are there, the big ones. But not approach everything to make the.
But where is your application for leave? You said that you had applied.
Always, yes, my lord, that is started from page 43.
Huh?
Page 43 to. So many. Leave application, page 43 to page 76. All our leave application. Forty-three onwards, annexure 7 to page 76, all our leave applications only.
No,
All the period.
this is
So
leave
that
from
is 2006, first one is of 30 August
1st August to
2006.
22nd
Second one is
September.
August 2006. Second one is 27 September 2006. Third one is again, my lord, 27 September 2000. Thereafter 6/11/2007. 6/11/2007. Then my lord.
What about the last one from
Last one,
2006 to
my lord,
2012?
10, 17/5/2010.
But you see, Mr. Counsel, for the there were prayers for leave. Even 2008, then 2008, then
12 is also there, my lord.
2 months from
75,
2009, 10. Applications were there,
Yes, my lord.
11.
2012 also so many applications are there.
These
That is
applications did not reach
71 is 11/11.
the
Then my lord,
112 to
72,
31, 1
27 January
2012.
2012. 72 page 70. In August 24. 2012. Continuously is getting application.
The period prior to 1/11/2006 has been regularized. Thereafter,
1/11/2006.
6 onwards, the matter is all recorded, all our representation applications.
Means the first two adverse remark
Yes, my lord.
are no longer adverse. The page number 87.
87, yes.
The first earn leave was from the period 1/3/2006 to 14/3.
Yes.
Those were regularized. 80 days, 80 days.
Yes.
80 days has been regularized.
Regularized.
Yes, and
Thereafter this,
Dispute arise from 1/11/2006 onwards.
huh.
All
But there
our-
are prayers.
All our application has been duly forwarded by the school authority to the departmental authority.
Even her prayer applications.
All leave applications.
Huh.
Now
But it is lying, tendering dust in the director. of-
now only let the, I am trying to helping her, your lordship. Let the authority examine her
all applications, and if possible, is permissible, they can regularize and release her arrears salary.
This
That
is what
action
has,
can be done.
yes. Let's see.
Instead of complicating the matter.
Hmm.
He'll not get it, because he cannot come and pursue him. He's going to school regularly somehow and teaching.
Somebody else will represent him. His son.
No, his son is, my lord, he's working in Hyderabad. And in Hyderabad or Bangalore somewhere.
Okay, I'll
Daughter
make
is
a,
studying, daughter is studying.
I'll write that a representative of the petitioner will go and pursue.
No man of company serviceman cannot take leave and come again and again,
No, no,
the
he-
director.
Not again and again.
He can file a detailed representation before the authority stating all the facts.
Hmm.
তাৰপিছত আকৌ আপোনাৰ case কৰিব।
Ah.
Most of the cases happen, then you have to file it.
Okay.
So Lordship kindly give some relief, will be from the on humanitarian ground.
But it seems there were prayers, there were applications.
Yes, applications are there, why they are sitting tight? What is his reply? That they are not, done nothing since 2012.
And page 87 are the adverse remarks, right?
Yes,
Is this a part of the service book?
yes, fine. Service book is.
Okay. Okay, right. Heard Mrs. N. Saikia, learned counsel for the petitioner, assisted by Mr. M.Z. Ahmed, learned counsel Koba, তাৰপিছত petitioner Koba, and Mr. R. Majumdar, learned counsel for respondent number 5, as well as Miss H. Terangpi, learned standing counsel for Secondary Education Department. By this application, filed under Article 226 of the Constitution of India, the petitioner has prayed for regularization of her leave period. Wait. For regularization of her leave period, as well as to release the arrear salary. Arrear salary is not given to you. Arrear salary also.
The increment is also not given. to
Arrear salary and the yearly increments with effect from 1/11/2006 to 3/9/2012. And also for expunging the adverse remark made in the service book. The case of the petitioner is that he was appointed as a subject teacher in mathematics in RCBP Higher Secondary School, Raja Bazaar, on 8th of November 1994, and his services was regularized by order dated 30/8/2001 with effect from 8/11/94. With effect from 8/11/94. Thereafter, the petitioner states that during his service career, he was treated for his heart ailment, and that he applied for leave by a number of applications. Full stop. The first one was for the period from 15/3/2006 to 18/4/2006, and the same was regularized by order dated 3/6/2008. Thereafter, another leave application was allowed for a period of 80 days, that is from 1/3/2006 to 30/6/2004. Oh, what 2004? The 80 days period was from?
Oh, my lord, different September.
was from
13 March, the 1st of March 2006 to 14 March 2006.
no, that is 14 days.
Thereafter, 19/4/2006 to 23rd of June.
66 days.
66. Then 66 days. Then again 7
আচ্ছা
days.
80 days বলে লিখিবা না
Ah.
80 days with effect
Okay.
from 1/3/2006 to 14/3/2006 within bracket 14 days. Then 19/4/2006 to 23/6/2006 within bracket 66 days. And 2/4/2006, no, that will be earlier. There's a mistake in the typing of the dates. Rose, 66 days.
Yes.
And 24/6/2006
6/2006.
to 36/2006. Which was again regularized by the authorities. However, thereafter, the petitioner stated that he had applied for leave on various dates starting from 1/11/2006 to 3/9/2012. But the said period was not regularized by the authorities. On the ground that no application was submitted for his leave, right? No application was submitted. The learned counsel for the petitioner, however, submits by showing the necessary documents that the petitioner initially had undergone treatment in the Silchar Medical College and Hospital, Silchar. No, 3/3/2006 is not in question, right? It was only from 1/11/2006, right?
As given in the prayer.
Those applications were without medical certificates.
আচ্ছা
Then it will work.
নহয় কি ক'লো এইটো লাষ্টটো তাৰ আগত দিয়া এই সেন্টেন্সটোৰ আগত লিখাচোন it was also stated by the authorities concerned that the petitioner was absent from 1/1/2006 without intimation.
1/11.
1/11 or 1/1? See page number 87. It is 1/11.
1.
So not 1/1, right? তেতিয়াহ'লে বাদ দিয়া সেইটো whatever I have stated সেইখিনি ঠিকে আছে যিখিনি আগত দিছিলো the learned counsel for the petitioner has submitted that the petitioner was undergoing treatment, right? Before the Silchar Medical College and Hospital and was admitted in the said hospital on 1/3/2006 and was discharged on 9/3/2006. And thereafter, he was again admitted in Christian Medical College, Vellore, on 27th March 2006 and was discharged on 12th of April 2006. These are the period where it is regularized.
Yes, ma'am.
No issue for his heart ailment. She has also placed that petitioner was constantly under medical treatment thereafter. And where were your applications? Acha, I've got it. Full stop. It is also stated that petitioner had made applications before the inspector of schools praying for leave on various dates That is, on 6/11/2007, the petitioner had made an application before the Director of Secondary Education for extending his leave on medical ground from 1/8/2007 to 31/10/2007. That is for a period of 3 months. Likewise, the petitioner had made applications before the same authority Let's see, the dates are so confusing.
Yes, my lord. you have-
Page number 47, this
Paragraph-
is,
Paragraph 6, page 7.
no,
All
page,
this
see,
is-
page 47. There he wanted leave from 1/8/2007 to 3/10. Okay, for 3 months. 31/10.
47.
Huh.
Yes, my lord, 6/11/2011. With respect and humble submission, I beg to request you and up to grant leave on medical ground for a period of 3 months, which effect from so and so, and of life. Time to time, as he is not cured and he has to undergo further operation. As I have submitted 3 operation he has undergone in his year, Christian Medical College, Vellore.
And
That's right.
also by subsequent letters, the petitioner had prayed for his extension of leave even for the year 2008 2009 2010 2011
Yeah,
as
that's
well
right.
as 2012.
Yes, all that's right.
Okay, you placed these certificates
Yes.
there, 2012. And the last application for extension of leave was for a period of 1 month with effect from 1/8/2012 to 31/8/2012. It will last no cover. It was second last one. And the last being a prayer made on 19/9/2012 for leave period for 3 days with effect from 1/9/2012 to 3/9/2012. It is stated by the learned counsel of the petitioner that the leave from 1/3/2006 till 30/6/2006 was regularized by the concerned authorities, and that only the leave period from 1/11/2006 to 3/9/2012 was not regularized.
Although it was forwarded by the inspector of
Ah,
school to the
was-
director of
Yes.
secondary education.
And a prayer was made before the Director of Secondary Education to regularize the said leave, since applications for the leave was presented before the authority. It is also stated that the Inspector of Schools had forwarded, oh no, it has a full stop. It is stated that the petitioner had submitted a number of representations for regularizing the leave period, and his case was also forwarded by the Inspector of Schools to the Director of Higher Education,
Secondary.
of Director of Secondary Education. Where is that forwarding letter?
We have not received, my lord, but my lord, it is said by the, whether.
Ach. Okay.
According letter has not been furnished to me.
As such, the learned counsel for the petitioner submits that the said leave period may be regularized and the yearly increments may be allowed. Yearly increments should be allowed to the petitioner during that period. On the other hand, the learned counsel appearing for respondent number 5 submits that the initial leave period was regularized. However, the later leave period could not be regularized in absence of the applications made for the same. However,
I am not the authority to regularize.
no, you are saying that it could
Yes.
not be.
Duly forwarded to the departmental authority. They are to examine and regularize.
And he submits that the inspector of schools have forwarded all the applications to the director of higher education, secondary education. And it is left to the secondary education to take a decision. Ms. Terangpi, learned counsel for respondent number, learned standing counsel for secondary education, submits that applications for leave were not received by the authorities. And as such, the said period from 1/11/2006 to 7/11 to 3/9/2012 could not be regularized. And the petitioner was absent during the said period and taking it as an unauthorized absence, the leave was not regularized. And the financial benefits was also not allowed to the petitioner. Para. Mazat ketan para koi diba, huh? It is seen from the records that the petitioner had made applications for leave during the said period not only for the period for which the authorities have regularized the said leave, but also for the period from 1/11/2006 to 3/9/2012. It is also, full stop, it is also seen in the records that petitioner was admitted in various hospitals and he was treated for his heart ailment for a long period of time. And he could not appear in his services. Because of the same. Para. It is as such directed that the petitioner would submit a fresh representation before the inspector of schools
May I submit my?
by annexing the leave applications made during the said period which although had been done, but for fresh consideration, the petitioner may submit it again. And the inspector of schools will again forward the same to the director of secondary education for its consideration.
Judgment also, my lord. Where my lord 50% has been allowed sick leave because the person is very sick. Somehow is doing 6 years leave. Is unable to
Where is the
continue.
judgment,
Yes,
please?
my lord. So, my lord, he cannot go and pursue it, my lord, of no. He cannot go and.
But see, online method will not be fruitful.
Not
So,
not
this-
at all. And the officers, government officers, you are watching, no, my lord, he cannot come personally. And my lord.
He need not come, he need not come.
50% salary is given, I have noted.
But see, the entire records has to be seen by them.
Apex court, my lord. Yeah.
So one of his representative would not come every day. One of his representative would come.
Petitioner thought was pursuing the authorities to grant sick leave on the ground.
Now that there is a High Court's order, that will have some.
Apex court order. That he is unable to attend his duties due to illness. Therefore, the competent authorities should.
Acha, send me the judgment.
Yes. Earlier I have given my here.
It's there.
Yes.
What is the citation?
Reading here.
I can see only one order by Justice Rishikesh Roy.
And order the Apex court allocation India ke baad I have the next page 17. This is another matter Radheshyam. This is the
I'm not able to follow what you are saying.
I'm saying my lord, one page 17 your lordship mein.
Page 17.
Para 19. In the
Page-
case of N. Balakrishna versus security officer
Hmm.
APSRTC.
But this citation, see, it will not be available. Do you have the,
To grant sick leave on the ground and he is unable to attend his duty. And another case, my lord, is of my lord, Irrigation, Supreme Court, my lord, Radheshyam Jadhav and another, become Irrigation. Hello. Can you read paragraph 30?
acha, ta agote di diba, sir, agote di diba. Hmm. 138. Hmm? Wait, I have not taken out. Yes? Acha, that was not in proper format and were not supported by medical.
Otherwise, since should not have priority.
Okay, that is why I'm saying one of your representative, you don't have relatives or what? One of your representative will come and give the representation because so many things has to be seen by the authorities.
It's okay, my lord.
But what I'll do is,
He's half that man also.
he has still not retired, it's okay. But
1.5 years or something late, my lord.
it's okay, I'll also write that you have shown in paragraph 19.
And my present salary on my lord paragraph.
This judgment is by you,
Yes,
Radhesham Yadav.
yes, sir.
Okay,
Paragraph
it was a
34.
decision. On the other hand, the learned counsel for respondent number 2 bulje kolu tar upor likhiba.
Yes,
Hmm.
sir.
Tar upor likhiba. The learned counsel for the petitioner to substantiate her argument has placed a judgment of the Honorable Supreme Court in Radhesham Yadav and another versus State of UP. Reported in 2024 INSC 7. Is this the citation? INSC 7, wherein the Honorable Supreme Court had directed
Paragraph 34, my lord.
this is in respect of leave.
Sick leave, medical leave.
Wherein this Honorable Court had where are the facts of this case? This was done, so and so has been placed in the form additional affidavit.
Beleg dila na. Sick leave bill kori na. Eta beleg diya samay.
Wherein this Honorable Court had allowed the claim of the appellants and direction was given to comply with the same within a time limit.
That's it, increment and my lord advancement, your lordship will pass about.
Okay, that I will say. আৰু তাৰপিছত এই যে ক'লো যে টেৰানপিত এটা লাইন লিখি দিয়া. She had placed, she submitted, that was the page number where you said no format? 1? She, by relying upon the affidavit in opposition filed by respondent number 5, but that was respondent number 5's affidavit. Nalage dia, respondent number 5 দিব নালাগে. She submitted that the leave applications of the petitioner on medical grounds were not presented in proper format and were not supported by medical documents. It tie line of.
1 minute, my lord, I object to it because my lord, it will not be accepted. Unless my lord separate where it will be bulky, that's why I am.
No, it was only her submissions. It was only her submissions, it's okay.
Accepted and not forward.
It's
Unless
okay.
You can now furnish.
Let her now furnish. Okay, তাৰপিছত যে লাষ্টত যোৱা. লাষ্টৰ আগত এটা দিয়াচোন. কেইটামান লাইনৰ আগত দিয়া, I will see, that the petitioner had clearly stated that he was pursuing the authorities to grant sick leave on the ground that he is unable to attend to his duties due to his illness. Etu প্ৰথমতে দিয়া, therefore it is seen. এনেকে দি দিয়া, that the petitioner was pursuing the authorities, As such, it is in fitness of the things that the competent authority should have granted leave if satisfied with the applications along with the application submitted along with the medical certificates. তাৰপিছত এইটো দিবা, লাষ্টত the competent authority should consider the application, the representation within a period of 1 month from the date of receipt of this order. It is further directed that the petitioner, being a sick person, would be unable to come down to the office of, can't he do it where he is? Can't he submit these applications?
Sure.
Silchar.
It will far, my lord, not.
And he has to come down to Gauhati.
He has to come to Gauhati.
Ki kolo, being a sick person would be difficult for him to come down to Gauhati and submit the representation. And as such, it is directed that one of his representatives would do the needful exercise. Full stop. Petition is disposed of. Because I have written that they should have considered.
Yes.
So now at the High Court's direction.
Regarding increment and advancement.
Everything.
Advancement should be advanced.
Regularize the leave, kosa no? Tate as well as for his
Increment.
arrear salary and the increment, yearly increment
Yearly increment,
during the said period
seniority.
from 2006 to 2012.
And my lord, two expungement that is illegally absent, that should be expunged. two remarks in the service.
Last diba before Okuman came, it is also directed that the authorities concerned would also consider the adverse remarks made in the service book.
Regarding illegally absent.
Full stop. It's okay. That will do, I think.
Obligation.
Otherwise, there is stipulated if rules is there.
Liberals, nae. It is not.
Let's see,
mentioned
he is
for
about to
bypass.
retire in next year, so if
That's why
something can be.
He's retired very soon.
I have no role to
Otherwise,
play.
he suffered.
I am the school authority. I have no role.
Obligation.
কালিটো হৈছে নি কালিটো হৈছে হা হা এই কালি নিচিনাকে ৰাতি দি পঠাব অনলাইন হা there's a limit to things. Yes, there are so many matters listed. There's a limit. Yes, this is 14-15.
Yes, ma'am. My pleasure, Lordship.
Hmm.
This matter is squarely covered by a Supreme Court order.
Huh.
Let us place the facts in two lines, madam.
One second.
Uh,
14-15. It can be taken up for disposal, Mr.
Yes,
Nath?
Squarely covered by Supreme Court.
It's a covered.
My lord, what the petitioner is a employee of the erstwhile ACEB.
ACEB?
ACB, my lord. Assam State-
ACB.
yeah,
Okay.
Assam State Electricity Board. Now, my lord, it has been divided in three sister companies. That is not the issue. My
No, I cannot hear you. Shout, you're a young person.
Yes.
Shout.
Sorry.
Yes.
My lord, what happened? In the year 2017, the revision of pay rules were brought into force in ACEB, ASEB. Now, it was given retrospective effect.
But ACB was bifurcated into this
Three
APDCL
companies. Now,
before 2017?
yes, yes. Now
Hmm.
it is APDCL, Assam Electricity Generation Company Limited and Grid Company Limited.
Mm.
Now, my lord, while adopting revision of pay rules 2017, it was given retrospective effect. That means it was given effect from 1st of April 2016. However, in the same rules, a provision was made that the preceding day, that is 31st of March 2016, if anybody has retired, they will also get the benefit of ROP.
Mm.
Now the authorities, what they did, instead of revising, this petitioner retired on the last day of March 2016.
So
Instead of
before ROP,
before ROP,
but
the-
retrospective.
yes, but the
Mm.
ROP takes into account this class of people also.
Mm.
Now, my lord, instead of revising my last pay, they only revise my pension. That's why the similarly situated person came before this honorable court, and the coordinate bench of this honorable court allowed the requisition directing them, no, first you revise the last pay, then calculate the pension. Against that, the department preferred a writ appeal. My lord. In the writ appeal, the honorable division bench of this honorable court reversed the learned signatory's order.
Mm.
And my lord, against the division bench order, we preferred a appeal, SLP before the honorable Supreme Court. Now, during pendency of the SLP, they furnish us the demand notice that in terms of learned signatory's order,
Mm-hmm.
in terms of learned signatory's order, we have paid you something. Now, since the division bench has reversed it, you give it back.
Mm.
Now, in the meantime, Supreme Court has now reversed the division bench order and upheld the learned signatory's order. So, in my humble submission, in terms of the Supreme Court's order, the demand notice has to be.
Achha, achha, achha.
Also, kindly peruse para 18 of.
You agree to this?
Yes, yes.
But on
You have to agree.
27/1/2026, Lordship may kindly see the order. The facts have been noted, my lord. On
Yes,
20,
Lordship, kindly peruse the.
Money is not given back, right?
Not-
Only demand notice was there.
Yes,
Lordship.
para 18, last but one page, para 18.
Paragraph 18.
18.
We set aside the judgment of division bench and restore. Appellant shall be entitled to the pay revision as on 31/3/2016. And their pay for the month of March 2007 shall be determined in the revised scale, and such revised pay shall be reckoned for computing the pension payable. The arrears of pay and pension shall be paid within a period of 6 months, and okay, fine.
In both the cases, at page 74, we have annexed the impugned demand notice, that has to be set aside and the petition has to be allowed. In
No,
terms
no,
of-
short case, so. What were you saying? You were saying something?
My lord, on Lordship can kindly see the last order,
Huh.
dated 27/1/26.
27/1.
27/1/26.
27/1.
27/1/26, Lordship has passed an order.
Wait.
Coordinated-
27, yes.
Well, the detailed facts have been recorded and I took time to apprise the Honorable Court about the outcome of the review petition, which we preferred before the Supreme Court. Malad. Now the review petition has been dismissed.
This is the order.
This is the order that
Yes,
he had
no, no,
given.
Against this, a review was filed.
Oh, against this, a review was
Review of
also
the
filed.
So I'll take
And review was dismissed.
dismissed now.
On what apparent error you had filed review?
But in fact.
Rightly dismissed.
Not,
Okay. That is the order?
that is the order.
Okay, heard Mr. J. Patwari, learned counsel for the petitioner, and Mr. D. Nath, government advocate, senior government advocate
For the respondents, yes,
for all the respondents.
APGCL.
No, APDCL,
APGCL, Malad.
APGCL.
Lordship.
You are for all the respondents?
Yes,
For all the respondents? By this application? Filed under Article 226 of the Constitution of India. This Supreme Court judgment was in the, during the pendency of
Yes.
this writ.
Supreme Court judgment is dated 4th December
Hmm.
2025.
Yes, wherein the petitioner has prayed, prayed for setting aside and quashing of the demand notice dated 11/11/2024. Number to Diwani. Demand notice number MD capital, / not required.
Because date is same, number with two cases, same demand notice, same date. But
There are two cases here.
yeah, 14 and 15.
Okay,
So issue number.
Number is same, date is different. What
date
is?
the same, issue number is different.
Acha. Notice number dear MD/APGCL /PEN /M-16/188/94 dated 11/11/2024. Full stop. The petitioner has also prayed for a writ of mandamus directing the respondents not to give effect to the said notice, demand notice.
And it was stayed by the order dated by the 22/11/24. This demand notice was filed.
I mean your filing date. What?
While we moved the writ petition, this honorable court stayed the operation of this demand notice by the order dated 22.
Oh, acha. That was the interim order.
That's
That
right.
will be okay, vacated. Then, sir, And also, a direction to the respondents not to insist for reimbursement of the excess amount paid. The case of the petitioner is that the revision of pay. What was the revision of pay rules 2017?
Yes.
Came into effect on
1/4/2016.
1/4/2016. And the said rules were made retrospective.
And a person who retired on the preceding day, that is 31st of
Yes.
March 2016.
And the persons who had retired before these ROP rules came into force would also be covered by the same. Full stop. The petitioner states that he retired on
31st of March 2016.
31st of March 2016. And that in view of the retrospective effect of the ROP rules 2017, he submits that he is entitled to get the benefits of the new ROP rules. However, it is stated that the authorities had allowed the benefits of the ROP 2017 only in respect of the pension without permitting the what do you say, the last pay?
Without revising the last pay
Without revising the last pay
drawn by the
or to last pay given to the petitioner. full stop, agreed by the said exercise by the authority concerned, the petitioner filed a writ petition being WPC number
4384 of 2023.
4384 of 2023.
4384 of 2023 in item number 14.
Is it written in the petition?
In the synopsis, my lord, I have given everything.
Acha, acha.
For the synopsis of both the cases. We have annexed the orders also.
Hmm.
On the top.
4384 of 2023. It be stated here. In an similar writ petition, in another writ petition, being WPC number 1607 of 2020, filed by similarly situated employees, in that writ petition, the revised of
This was the first in point of time. WPC 1607 of 2020.
2020, wherein the learned single judge has allowed revision in the last pay of the employees. Wherein the learned single judge has allowed revision of the last pay of the employees. And thereafter to calculate the pension.
Absolutely.
The same, full stop, the same order, a similar order was also granted to the petitioner by order dated 29/9/2023. And the said writ petition 4384 of 2023 was allowed. Against the said order, the authorities preferred a writ appeal before the Honorable Division Bench of this court. And this court, by order dated 3/11/2023,
is a single judge order. Division bench order is 5/8/2024.
that is not written in a synopsis of 5/8, yes.
Ninth line from the top.
No, writ appeal, no. And this court, by order dated 5/8/2024, not 3/11, 5/8/2024, had allowed the writ appeal and had set aside the order passed by the learned single judge. Full stop. Against the same, the petitioners and others similarly situated,
I have written the name.
petitioner and another filed a special leave petition before the Honorable Supreme Court. And the Honorable Supreme Court, by order dated, passed in writ has been assailed before the Supreme, by order dated 30/9/2024. No.
That was the interim order.
That was interim.
Just now I have given.
Honorable Supreme Court, by order dated
4/12/25.
4/12/2025, had restored the order of the learned single judge and had set aside the judgment of the division bench, Honorable Division Bench of this court. Full stop. The Honorable Supreme Court had given the finding that the appellant stroke petitioners shall be entitled to pay revision in their last pay, in their, with regard to the last pay received by them, and such revised pay shall be reckoned for computing the pension too. And further concluded that the arrear of pay and pension should be paid within a time stipulated therein, with interest, with 6% interest.
during the pendency of that SLP, this demand, impute demand notice came out.
Yes.
At page 70.
The said Supreme Court, the said judgment of the Honorable Apex Court was passed during the pendency of this writ petition. It is further stated by the petitioner that pursuant to the order passed by the Honorable Division Bench of this court and during the pendency of the instant writ petition, demand notices, where is the demand notice?
At page 74.
Demand notices were served, was served upon the petitioner. Page 74, right?
Yes, my lord. Page
For
74.
recovery
Yes.
of the amount paid by way of revising the last pay drawn by the petitioner. It was stated therein that the excess amount received by the petitioner. This is to Binod Bhagavati. This petitioner is Binod Bhagavati, yes. The excess amount received by the petitioner on account of revised pensionary benefits as per ROP 17 and by rejecting their application, rejecting his application, a demand was made to the petitioner to refund the excess money said excess money. Full stop. Para. These demand notice dated 11/11/2024, as mentioned above, are in teeth of the judgment passed by the Honorable Supreme Court on 4th of December 2025, as stated above. Learned government advocate has also fairly submitted that the said demand notice would not stand in view of the Supreme Court's judgment. In view of the same, the said demand notice dated 11/11/2024 is hereby set aside and quashed. Nothing more. And some revised thing is already done. Pension is also calculated. The petition is as such disposed of. Allowed. Yes. Petition is as such allowed. What about the next one?
Next one, everything is same. Demand notice is also same. Only the WPC number is 4381.
Oh, hey, WPC to bodlai diba and the demand notice or posted it as
Demand notice date is same.
number is different. And the petition number is 1607, huh?
No. Petition WPC number 4381 of 2023.
That was also 4381, no?
84.
Oh, yes. 4381. Yata ma mark korisu. Eto dheri our number to it. Petition is allowed. Okay.
Simply obliged.
Yeah. Yes, Mr. Munir. He was sitting here for long. Yes. Some affidavit by somebody required to be filed? Yes, Mr. Yes.
They were supposed to file, but they produced one office memorandum, my lord. It's on record, my lord.
Mr. Roy is for
Respondent, my
You
lord.
both are actually same, both brothers, but then what happened? You're now separate. Acha, Mr. Roy for?
CCI, my lord, Cement Corporation of India, Bokajan Cement Factory, my lord.
Acha, acha. Cement factory.
Cement Factory, my lord.
And you, Mr. Munir, what relief you want here from them?
Well, what had happened, the petitioner was removed from the rolls of service.
Acha.
And thereafter, my lord, we challenged the.
So pleadings are complete,
Pleadings are complete.
can be taken for disposal.
My lord.
Ready? Okay, I'll give a short order. Yes.
Thereafter, my lord,
Wait.
I would like to.
Let me
pray-
see. What is the cause of action? What happened? He were removed from service.
Removed from service, we challenged the order, my lord, here, petition was dismissed, but there was a direction, observation, my lord, page 16 may kindly be seen. That is the order of the court, my lord.
Page 16.
16. The operating part is in page 16.
RDV is there. Total. Wait, just a second. What is it? Oh, Miss CGSC RDV is there. She is on leave. Her presence is required.
No.
And senior counsel is the main.
Oh, you are for
Cement
I am for the Cement Corporation, my lord.
so Union of India. No,
Cement
Not
Corporation.
Union of
Cement
India, my lord.
Corporation. That's the corporation.
I'm the corporation, my lord.
Who appears for Union of India is a party. Huh? You are for Bokajan Cement Corporation, right? And RDV is the CGC,
CGSC, my lord.
not an assessor, not required.
Or lordship may take up the matter day after tomorrow, my lord.
What will happen day after tomorrow? Some
They-
CGSC will come.
No. Today I got to another matter which is very important.
Otherwise, you will be stuck here. If it is a short matter, your junior can be here and you can
My
leave.
lord, Monday, my lord,
Monday.
Monday.
As requested by the councils appearing for the parties, list this matter on 18th of May.
Oblige.
Yes, Miss.
Yeah, Lord. My lord, and this is
Chakraborty,
the
no?
instructions that I
Huh.
have received is that the petitioner may submit his original HSLC certificate. There's some dispute regarding date of birth.
Mm.
So the government has already taken up the matter for release of pension, but for this certificate, so he, the petitioner may approach the authorities with the original certificate, HSLC certificate.
That will kind of dispose of the matter.
Let it remain pending, my lord, for the interest of the petitioner on them.
Acha.
Let it remain pending.
Before that,
Yes.
Lordship, may I please, your Lordship, take up to the order dated 9/1/26, Lordship?
9/1/26, yes?
Yes, for
Hmm?
9/1/26.
I'm
Lordship.
making submission for his benefit only.
Hmm.
No, Lordship.
So you do one thing, you submit your HSLC certificate.
HSLC.
He is the
HSLC.
grade 4 employee, Lordship. He has not passed the HSL. They are seeking
Oh.
the HSL certificate.
But there's some dispute regarding date of birth. Therefore, it was returned by the Accountant General's office.
So you place any certificate where your date of birth is reflected,
Yes.
right?
Yes,
If not HSLC, then something else? Birth certificate?
it will only can say the department whose document I have to produce, whether it's Aadhaar card, PAN card, or any other documents or affidavit.
Age proof.
Age proof to Aadhaar card and all will not do. Any school certificate when you were studying there?
Because even again, we send, it will be returned by the Accountant General, my lord. Accountant General's office, it was returned with the note regarding disputed date of birth.
So here the entire dispute is of his date of birth.
Mine.
Yes, that is from the beginning, Lordship, but this honorable court passed an interim order, Lordship, considering the petitioner medical condition, Lordship, specially. And on order dated 9/1/26, on the last paragraph, Lordship, there was a direction to release the provisional pension, an arrear thereof, Lordship. And there
Oh,
was,
you have already retired.
yes, yes, Lordship. The person is on deathbed, Lordship. and Highly need the medical support and the financial assistance, Lordship. That's why this court directed.
Today, what is your prayer?
To my simple prayer to the Lordship, we will comply whatever the requirement for the correction of the data.
My lord, may I
But
submit?
before that,
Let-
Lordship-
Let them, one of them visit the authority, the district authorities, or maybe here the government also, under secretary, and furnish whatever is there available with them, so that the
Showing
process
their
can
date
be-
of birth.
Yes, my lord. Because I have also taken personal interest owing to the ailment of the petitioner.
Hmm.
So he may approach the authorities because without these documents, even if we forward this to the Accountant General's office, it will again be returned.
So that is a shorter way of getting your relief.
For final release of pension, that's okay, Lordship, but till before that, then let them release the provisional pension, then.
Without documents, how can provisional pension also be released, madam?
Why not? Initially, this state department was released the provisional pension and there was dispute come that he is not entitled.
But
for the
provisional
service
pension
period.
though can be released
Yes,
without,
Lord, when there was specific direction.
Because
of the
we
Honorable
had,
Court.
my lord, forwarded this thing. I have got specific instructions and then it has been returned by the Accountant General's office.
why
Or
not
your lord-
provisional pension?
Provisional pension. Your lordship gives a direction to the Accountant General's, then my lord will forward that proposal again, my lord. Whatever documents we have with the department.
Already there is a direction, Lordship, on 9/1/26, Lordship, last paragraph, Lordship.
Is it into corridor? I know, I know.
So you require 20 years of service.
Yes.
So in order to see that, you want that
Yes.
20 years of qualifying service. But
On that ground, it was returned by Accountant General.
20 years of
It was
qualifying service will
Taken
not.
care of by the judgment, my lord, Sanjita Roy's judgment.
Sanjita Roy judgment.
That's how, my lord, your lordship had directed that provisional pension may be released at this point. But for that, we need some document of the incumbent. Without any document, we cannot form,
Once the eligibility is already proved, Lordship, the provisional pension may be released, Lordship. In paragraph 7 also, it has been stated on the state order, Lordship, on 9/1, Lordship.
They wanted to help them, but then
So you had 2 dates of birth, right? So there was a confusion
Yes.
and so the authority could not release your pension. So as per this last order, as you have said, 9/1/2026, you see, that was kind of a complete order. On this verification, respond number 4 shall process the proposal of the petitioner afresh. So they could not clarify
Yes.
about the date of birth. So you submit one certificate and then the rest will be done. Water Resource Department shall authorize the petitioner provisional pension with effect from the date of. Achha, provisional pension, that direction is already there.
Yes, Lordship, but they are not releasing.
The said
Lordship.
provisional pension along with the area shall be released within a period of 1 month. Receipt. So provisional pension was already ordered for.
it was ordered, my lord.
Huh.
But then it was returned by the Accountant General's office, my lord.
But for that, for allowing provisional pension, department will not require his date of birth. His
But we don't-
otherwise
my lord,
services
we don't require-
admitted.
We don't require, actually, my lord, the Accountant General office will be the best authority to. decide.
You are representing water resource.
Water resource.
So the accountant general will not require date of birth in order to release provisional pension. Okay, for the pension he might require. So as far as provisional pension, there is already an order.
My lord.
Water competent authorities in the water resource shall authorize to the petitioner a provisional pension with effect from the date of his superannuation. So as far as your eligibility to pensionary benefits, this date is crucial.
Yes.
So for that, provisional pension they'll have to release, and for that your pensionary benefits you go and give one certificate.
Sure, Lord.
Okay.
Well,
Will you
it
do,
is-
Mr.
it is-
Ms.
so the
Chakraborty?
petitioner is on-
Yes, no, anybody can.
You or any representative
Any
will go.
representative.
Heard, Mr.
PA Chaudhary.
Mr. T. A. Chaudhary, and this will be kept pending.
Yes, ma'am, let it be.
Mr. T. A. Chaudhary, learned counsel for the petitioner, and also heard Ms. P. Chakraborty, learned standing counsel, Water Resource Department, and Ms.
B. Nandini appearing on behalf of Arthur Talukdar.
B. Hazarika on behalf of Mr. R.
Nandini
Nandini, on behalf of Mr. R. K.
Talukdar.
R. K. Talukdar for respond number 4.
Accountant general.
Huh? Accountant General. And Mr. C. K. S. Borua for respond number 3, that is Pension and Public Grievance Department. While order dated 9/1/2026, it was held that although the petitioner is eligible for being, although the petitioner is eligible for his pension and pensionary benefits in view of his 20 years or more as qualifying service. However, the administrative department was required to clarify on the date of birth of the petitioner. It is seen that there were 2 dates of birth emanating from the records. And respondent number 1, 5, and 6 was directed to verify from the records, service records of the petitioner, from the service records of the petitioner, the actual date of birth, and communicate to the Accountant General Office along with the pension proposal. But when the matter is taken up today, the learned counsel for the Water Resource Department submits that the respondents could not clarify on the date of birth of the petitioner on the basis of the available records. And as such, it is submitted that the petitioner may go and submit a document showing his date of birth, showing his actual date of birth. Full stop. Further, in the said order dated 9/11/2026, it was directed that since it is settled, the competent authority in the Water Resource Department shall release the provisional pension to the petitioner with effect from the date of superannuation from his service. Full stop. It is as such directed that the petitioner may approach the office of the Water Resource Department,
They may approach the divisional office also, my lord, at highlight.
may approach the divisional office of the Water Resource Department, Government of Assam, and submit a document showing his actual date of birth, which will be further forwarded to the Accountant General Office for doing the needful. That will do. Release this matter again on after 1 month or what?
Let it be 1 month.
Release this matter again on 17th of June.
AG may be directed to release the provisional pension.
It is already there. I have already said. It is already there in the
The
order.
learned friend said AG already returned this proposal.
return the final proposal, but as far as provisional pension is there. Huh? List this matter on so and so. The office of the accountant general would consider the the document placed by the petitioner and do the needful exercise within a period of 1 month from the date of receipt of this order. How is it? Not disposed. Release this matter again. We will see what is done. Yes. Yes, Mr. Chaudhary. Bail duta mati diya, 3:30 hol. Yes.
Lord, here it's a clear case of Milord discrimination.
For disposal?
Having regularized Milord.
For disposal?
Yeah.
What about the other party?
Other party.
Who is appearing? S. Borua.
As Borua for pollution. control.
Pollution control or PJ Fukon.
I'm just a formal party.
So what happened to S. Borua or PJ Fukon?
We are sending for him. No? My Lord, the petitioner was initially.
You call him Mr. Gogoi? Yes.
Page 24, my Lord.
Hmm.
The petitioner was appointed on contractual basis in the interest of board service.
The contractual basis in which office?
Pollution Control Board.
Oh,
Gauhati
acha.
office.
Firdausi Rahman Chaudhary?
Yes, the
Acha.
petitioner number 1, my Lord.
Hmm.
Along with another Digonto board.
Hmm.
Contractual or the consolidated pay of so and so, so and so, so and so. Then, my Lord, at page 26,
Hmm.
this was in 2011, my Lord.
Okay.
Then in 2018,
Hmm.
my services were regularized.
Hmm. Yes.
In the interest of public and board service, Firdausi Rahman Chaudhary, data entry operator presently working as fixed employee of the board under the regional office, PCB. Her service is hereby regularized in the board as data entry operator in the pay scale of so and so, with grade pay of so and so as admissible under the rules. With
What
effect
happened,
From the
Mr.
date of her.
What happened, Mr. Gogoi?
We tried to reach him, and he's not responding.
So can it be taken tomorrow, day after?
Yes.
You, yes, your junior can
Yes, yes.
inform.
In
That can be
case, my Lord,
Taken as a first item or something?
yes. Tomorrow.
At your convenience, whenever you are free. Whenever you are free, I'll take it.
2nd of June, will it be convenient, my Lord?
2nd of June is too long. It's okay then.
Actually, my Lord, in between, I'll be not there for some time. my Lord.
Acha. Some foreign tour.
No.
Acha.
Actually, my Lord, one of our friends' daughter is getting married in Sri
Oh.
Lanka.
Oh, acha.
They were in Sri Lanka, so he's getting married to a Sinhalese boy. So
Acha.
we all are going, my Lord, on
Oh.
20.
So I was partly correct.
Fine.
Acha. Okay, then
2nd of June, my Lord.
2nd of June. As prayed for by the, not as prayed for, as prayed for by the Learned Council for Respondent,
Ah.
list this matter on 2nd of June, 2026. Bail kita mati do bail. You have some other matter, Mr. Chaudhary?
Yes, sir. The item number. 66 to 89, Mr. That's a small matter.
Acha.
Milord, the matter is something like this, Milord. These are all central government class 1 officers, Milord. They were, once they're posted in Northeast, because it is not a family zone, therefore they are entitled to retain the family quarter at the last place of posting. And this
Allotted
is
family quarter at the last place
last
of
place of
posting.
posting.
But they will work in Northeast.
And there is a statutory rule which provides for this.
Now, by my lord, executive order, this rule has been, my lord, overridden.
But
Now
the
they are-
rule is in detriment of the officer.
Yes, that's the only very simple point.
Huh. Okay, CGSC is
Yes,
there.
yes.
If Lordship takes up, I have to call Mr. R.K. Dev Chaudhary. He is supposed to address in that case, Lordship.
A very small matter, my lord.
Because if I have two bail matters, so I can take it up today subject to the approval of the other councils.
Yes. And most interestingly, my lord, in other departments of similar officers, they are having the benefit. It is only the, my lord, Group A officers who have been disturbed. A Group B, C, they are all retaining the same position. Well, there is a simple point, my lord. How can you override a statutory rule, 309 rule, by an executive instruction? That's the only
It
point.
cannot be.
And on the contrary, my lord, the Group B, C officers are able to retain we cannot.
Achha.
And my lord, moreover, the Armed Forces Special Power Act is in force in 31 districts in NE.
Hmm.
So how can they say, Mr. things are normal?
So can it be taken up now?
I'm ready, my lord.
I have intimated him. He's coming.
Oh,
Achha.
let him come, learn here.
Yes. এতিয়া অলপ পিছত লওঁ মাতি দিয়কচোন আৰু কি আছে Oh, he has come. What about item 19? Yes.
Small matter, my lord. Pay has not been paid, my lord.
Acha.
Your Lordship, I'm appearing on behalf of D. Bora, Standing Counsel.
D. Bora.
Yeah,
Hmm.
she could not appear due to some medical emergency before the Honorable Court. So if you'd be so kind to give us a date after 12 days, 15 days.
You have filed your affidavit? No. Huh?
Let them.
Due to some medical emergency, they could not come. I can instruct.
Do you have instructions that they will file affidavit?
I'll have to consult once, Lordship.
Okay.
My lord, one small point is there, whether my post is stenographer or stenotyping, whether there is a difference or not. Let them clarify by
Okay.
filing affidavit.
Okay, tell your senior to verify, to bring the verification on that. Okay. As prayed for by learned counsel appearing for the respondent, Miss,
D. Bora,
you
no.
are
R. Sharma,
R. Sharma on behalf of Mr. D. Bora.
Miss
Ms. D. Bora, learned counsel for
Health and Family Welfare.
learned standing counsel for health and family welfare. List this matter again on what date? List this matter again on
2 weeks.
5th of June. 5th of June, 2026. Yes, Mr. Chaudhary, Mr. RKD Chaudhary. Are you ready with the case? We can take it up.
Here, Lordship, my senior friends, they have filed an affidavit, bringing on record a communication of 30th March of this year, whereby, Lordship, the Ministry of Home Affairs has taken up the matter with the concerned ministry for retention of the quarters till 30th of this month. So I need to take some instruction on this because it is an interministerial thing. And I would be on both sides.
Yes.
That is one difficulty. Otherwise, I am opposing him.
But my lord, the nodal ministry is the Home Affairs. Home Affairs have
no.
permitted it.
No. Here, they are occupying the quarters, which is under the estates.
Huh.
The basic thing out here is the CRPF, the BSF, they have got their own quarters.
Huh.
But the quarters under the Directorate of Estates are better. So they don't want to release that.
So they are staying there.
They are staying there.
No, my lord, this is not better or not better. That is not. the
And
issue.
in any
It's a
case-
question of right flowing from a statute. There is a set of. If your lordship kindly permit me, I can just place one thing. My lord wants to go. Please have a look at this, my lord.
He cannot was to say.
Just for a minute, my lord. Please come to my lord, page number 115 of the petition.
Yes.
Rule
115.
43.
115 is not rule 43, it's a
Yes,
part
my
of
lord,
some.
page 115 of the petition,
Acha.
the rule starts at 111.
No, this is a part of some order, some.
No, lordship will kindly have the writ petition, my lord.
Huh?
9 to
Repetition.
5.
Oh, 1535 I'm holding.
9 to 5 to the option. Item number 67 to the option.
67, next to.
9 to 5. 249. Very on the option.
115, right?
Please come to 115.
Hmm, yes, yes.
Before
Huh.
that, please come to 111.
Hmm.
In exercise 16th of June 2017, in exercise of the power conferred by proviso to Article 309 of the Constitution of India, and in supersession of the allotment of government residential general pool in Delhi Rules 1963 and Garage Rule 1964, except as respects things done or omitted to be done before such supersession, the President hereby makes the following rule: a regulating allotment of accommodation to central government employees at various places of the country under the control of the Directorate of Estates, Ministry of Urban Development, namely. So this rule may be called Central Government General Pool Residential Accommodation Rule 2017.
Yes.
Now please come to 115.
Hmm.
Rule 43.
Hmm.
Retention granted to allottees, including Agmuk Kader officers of GPRA. GPRA is, my lord, General Pool Residential Accommodation. At their last place of posting, in case of their posting to different non-family stations for bona fide use of their family members under different guidelines of the Government of India, issued from time to time, will be restricted to maximum of 3 years.
So
So, my lord,
retaining.
supposing
Huh.
I am transferred out from any place, my lord, say in 22. So I can retain it up to 23 years, up to 25. So that they are not permitting. We have retained, but they're trying to charge me lord penal rent now. Crores of rupees has been raised. In one of the case, my lord, one of the more than 1 crore has been, my lord, raised.
So what I can understand is,
Yes.
they will go to the transferred place, whatever,
Yes.
but they will
Because
retain
it's a
their
non-family
quarter,
station.
non-family station.
Yes.
They'll have to be alone there.
Yes.
Family will stay at the last
Yes,
place of
for 3
posting
years.
for 3 years.
Yes. Now,
After
my lord,
3 years,
kindly
what
come-
will happen?
Well, after 3 years, we will have to leave it.
Leave it. Then they will stay where?
That is the rule says, my lord, we are not questioning that, we leave it. Now, what had happened, my lord, because there was a stay order in this proceeding, because we are continuing. Now, their count, my lord, they are imposing panel rent.
Means after 3 years.
Yes. No, they are counting from the day one.
Why?
Because by an executive order, this order has been, my lord, now
Oh.
modified. Not by amendment of.
So what is the executive, although it's illegal, but what
Yes.
is the?
Now, page 104.
Yes. This
First,
is
my
the.
lord will kindly come to 102, my lord.
Yes. 102 B or A?
B.
Yes.
By OM dated 10/4/2018, retention of general pool residential accommodation at the last place of posting by central government civilian employees, including CAPF, that is Central Armed Police Force, to whom we belong, my lord. Officers of All India Service posted in non-family station was extended up to 36/2021. It has now been decided to further extend the concessional retention of general pool residential accommodation at the last place of posting by the central government civilian employees, including CAPF employees of All India Services on their posting to non-family station for a further period of 3 years up to 36/2024. Then, my lord, this order has been done away with at page 104. So we have impugned this mill. 104.
Hmm?
Reference is invited to this directorate's OM dated so and so. They're referring to the earlier OM from there, last being 8/4/21, by which Lord, it was extended up to 30th of June 24.
Hmm.
Now I'll have your lordship's kind attention to subpara 2.
Hmm.
Now the government has reviewed the incentive special allowance granted to all India service officers and central government group A service officers working in Northeastern region. And accordingly, it has been decided to withdraw the benefit of retention of government accommodation at the last station of posting insofar as it relates to group A officers, including all India service officers as was granted by OM dated so and so.
Acha. So
As
they,
per above,
huh.
no press retention at the last place of posting shall be granted to Group A officers, including all India service officers with immediate effect, in case of their posting to Northeastern region, including Sikkim. However, provision of such retention to officers posted in remaining non-friendly stations like Jammu and Kashmir, Ladakh, Andaman, Lakshadweep, so and so, as declared by Ministry of Home Affairs from time to time, shall remain in force. Moreover, the retention already granted to such officers who have earlier been posted in Northeastern region during Sikkim will also be withdrawn, subject to any stay already granted by any court of law against any vacation order, giving opportunity to the allotee officers to vacate the accommodation latest by so and so. In all the above cases, as mentioned in para 3 and 4, normal retention period allowed on transfer under rule 40 of the so and so rule shall remain applicable from the date of transfer. Well, rule 40 speaks of some unforeseen event taking place, somebody dies, something happens, then one time is given. So this is neither here nor there. So paraphrasing, how a right which flows to the petitioner from the statutory rule framed under 309 can be tinkered with by this executive instruction. That is our case.
Now they'll have to vacate.
Vacate. Now there is an interim order operating in all these proceedings pending. So this is the case. And recently, my lord, we got that document which has been issued by the Ministry of Home Affairs, which says it is permissible up to 30th of May 2026.
To stay there.
So I need to take an instruction on that, 30th of May, because.
But anyway, the moot point that 309 rule cannot be superseded by this.
Lordship will kindly come to page 31 for a moment.
31.
For a moment. As a part of the prayer, they want to stay till 30/6/2024.
This is the prayer.
That's the prayer. The period is over, Lordship.
Acha, what prayer?
They want an extension till 30/6/2024. No. That is okay. No. That end of the day, the relief has to be modulated in accordance with Rule 43. No. Up to 3 years we can retain. Thereafter we have no right. Neither we are claiming. My lord,
this was not drafted by you. So this is the.
No, Lord. I'll apply the principle of actus curiae nemmem grevebit. Court's order cannot prejudice anyone. There is a stay order. That stay order cannot prejudice central government.
No, that has been provided for if there are any stay orders.
So, my lord, court's order cannot prejudice anyone.
So you want at least for 3 years.
Create any equity, nor it will prejudice anyone. Now, so far.
See, one thing is that the armed forces will work somewhere.
Yes.
Family will stay in the last station. That also you are doing away with.
Now, kindly see, my lord, border roads are being constructed by the CPW people. Who protect them? The BSF. Us.
Yes.
They are getting. They are getting that benefit. We are not getting. As a security provider, we don't get. But person whom we protect, they are getting the benefit. Now, this is the extent of Miller violation of Article 14. It's an absurd case.
Okay, you bring instruction on this last study.
I will bring that instruction. Treated as partner person, lordship as partner. Am I hearing is over?
No, partner is not there.
Insofar,
otherwise, that is the point, your small
yes.
point. Although the petition looks big.
Yes.
In so far as his relief is concerned, specifically in this case, that he has got, Lordship. He wants to stay
That
till
is this.
34.
Till
In the other
36,
cases,
24.
maybe. In the other cases, maybe. But so far as his petition is concerned, he wanted to stay till 34/2024. He has stayed there. Now, the petition itself has become infructuous, so far as his case is concerned.
This is
Technically.
Yes,
Yes.
it was not drafted by him.
Imposing
That is
penalty now. They are imposing
Definitely, we will impose.
No, provided
Yes.
your action is correct, you can impose. provided the court gives you the liberty.
Lordship, let it be whatever.
Even in a representation, that was the cutoff date or what?
The prayer, Lordship,
Uh-huh.
not
Okay.
only in his petition, there are other petitions also. I have the numbers where each of them has prayed for allowing them to stay there till 30/6/2020. So those petitions have become infructuous. Lordship can take up the other petitions.
No, subsequent IAs have been filed.
You cannot go
where
on
the prayer
developing
has
your
been
case by filing
But
IA.
relief by way of an affidavit will not do.
Because of the pendency, because of the circumstance, at times, my lord, it may be permitted. There's no, 226 proceedings are not that technical. The end of the day, people come here to enforce their fundamental right. It's not a civil proceeding, my lord, where the procedural law, my lord, holds the field. Here, end of the day, lordship is, it's substantive, lordship grants substantive relief. Why? Because there's a violation of fundamental right. How can, my lord, the CPWD officers be given this benefit and the BSF officers, my lord, who provides them security, they are not being provided. And my lord, Government of India has still declared any reason is a non-family station. You yourself created this discrimination.
I will clarify that on the next day, Lordship.
Okay.
And 31 district, my lord, in the northeast is covered by APSPA. So you are saying everything is normal. Even if everything is normal, how come 31 districts are disturbed?
Okay. Heard Mr. K.N. Chaudhary, Learned Senior Counsel, assisted by Mr. Yes, Learned Counsel for the petitioner, and Mr. R.K.D. Chaudhary, Learned SGI,
Deputy SGI.
Deputy SGI, assisted by
L.
Learned Senior Counsel come Deputy SGI, assisted by Miss B. L. Devi, Learned Counsel, and you are also with him, as prayed for by Mr. R.K.D. Chaudhary, Learned Senior Counsel, that he requires to get, that he needs some further instructions
On the office memorandum dated 30 March 2026.
in view of the office memorandum dated
Yes, Lordship.
31st
30/03/2026.
3/03/2026. They has prayed for some time. Prayer is allowed. List this matter when? List this matter again on 2nd of June 2026.
There are 3-4 other similar matters that given the list, it may come together.
No, it
Yes.
is all coming up.
It is submitted.
I don't know.
Acha, it is submitted that there are analogous matters
Detail.
which requires to be listed along with the instant matter. Prayer is allowed. The analogous matters being
Yes.
so and so number,
I'm
head
giving
division,
the number.
yes, be listed together with the instant
And
petition.
interim order will continue. please.
Interim order passed earlier shall continue until the next returnable date. Acha, Nambu Didiva, Mr. Gogoi, for in,
This is better, there is no timeline. I'm praying for entire passment of this.
acha, so better case,
It's.
better case. Okay, for in item number, Heri Didiva Gogoi na, and who else? Rest, Mr. Chaudhary, yeah? Right?
Yes.
Yes. Okay,
My-
what item number?
My, 80, 82 and 85.
80, 82, 85 or Gogoi nam diba.
Interim is there.
Interim order will be extended.
Okay.
Yes, Mr. Bothakur. You need not worry. Yesterday,
Yes.
Mr. Parashar had gone
yes,
into
madam.
the records.
Sir has told me that already hearing concluded,
Ah.
but regarding those points, madam.
In fact,
We
Mr.
have to
Chaudhary,
clarify
after you
some
left,
things.
I wanted you to come back.
Yes.
After you left, KK Parashar had seen the records and he had found out that medical treatment, medical examination was done on the day of your arrest, the next day of your arrest, and even on 27th.
My
Right. So that point also goes.
only one point, my lord, in respect of journal hawk, not Johrul Haq. In Johrul Haq, my admit, only journal hawk, my lord, because journal hawk cannot be treated as the possessor of the contract.
The driver.
He is the only riding the bike, my lord, motorbike. The contraband was found at the shoulder of the Johrul Haq.
In a
What the figure?
backpack.
Not backpack, he is at his shoulder, man. It is written in the FIR.
But see, a backpack, I read yesterday, it was
Yes, yes,
backpack.
backpack, my lord, yes, backpack.
Finally, the FIR first.
And my lord, regarding now, if he wants to dispute all these things, my lord, then matter has to be taken up some other day. Otherwise, already you're not.
Points goes.
Yes, my lord, all these points, my lord, one after another, my lord.
19 and
Every
20,
time he has
last
taken
month.
new points, my lord.
FIR, not a new point, my lord, only for your perusal.
Yesterday, you had raised 2 points.
Yes, ma'am.
One is that his appearance before the magistrate, and the other one is this medical examination. Now, what is the third point?
Third point, in respect of journal hawk, not journal hawk. Because kindly see page 19 last, FIR,
Huh.
last month. I along with police party used by the departmental vehicle bolero number so and so, Patalgandi, so and so.
We intercepted the said bike rider along with a pillion
Yes.
near so-and-so, and our operation team rashly approached near to them, and suddenly they tried to escape. Our operation team so-and-so detained both the rider and the pillion with bike, and pillion, namely Johorul Haq, carried a red and black color of bag in his shoulder. There was a bag. And on asking both of them, they introduced as Johorul and Joinul. And so in his back, it was bag. It was found.
It is shoulder, man.
Shoulder. Of course, the bag was hung in the shoulder.
Shoulder.
So shoulder, this is in respect of whom?
Johorul hawk.
Johorul Haq. So Joinul Haq, you say that he was not possessed.
Not possessed.
But he was along with Johorul.
Yes, well, active possession of both joint
the
hawk and
motorbike, and
vehicle.
that motorbike also not owned by the journal mine. It is the owner of the motorbike is the younger brother of the journal hawk. So
Johorul and Joinul Haq are brothers.
not brother,
Ah.
not brother.
Hmm.
It is the Johorul Haq house is situated nearby the house of journal hawk.
Hmm.
So when journal hawk was going, suddenly my lord, that person was.
How can I, these are all assumption, presumption.
These are assumption I think, but only I am saying that the person who was found in possession, the bag in the at the shoulder of the Johorul Haq.
Johorul,
Johorul, not Joinul.
not Joinul.
Joinul is only
But
riding the-
Joinul is along with him.
If my lord,
See, the other two we have released on bail because nothing was found in their possession. Now these two people were together, and now I cannot just distinguish between them.
distinguish why, because that bag was not found in the motorbike.
And again he will say that it was inside the bag, and bag should be held responsible,
This is
not the
written in
person.
the FIR.
No. This I am
In
rejecting.
case of my lord, distinguish any one of them, then both should be allowed to go on bail, my lord. Otherwise.
Heard Mr. H.R. Chaudhary? They are not.
Then
They are
my
not.
lord, I would like to allow to withdraw the both of this.
My lord, at
I'd
this
like
point,
to-
how he can, my lord,
Because
see,
my lord,
how does-
After hearing so long,
it was passed on to my class instruction, my lord.
No,
Because last night, my lord, the.
see, drugs is creating menace in the
Yes,
society.
right,
Many
not-
families have got
No,
destroyed.
I'm withdrawing. I'm withdrawing. I'm withdrawing.
Okay. Okay.
my lord, at this point, after hearing, my lord.
Yesterday
prayer-
also
prayer
today.
Make my prayer before
Even
lordship, my lord.
Mr. Parashur is
And
also
today
not
also
there.
matter is
So maybe withdrawing, my.
Parasar is not there, that's why, my lord, initially, my lord.
It's okay.
You are not interested.
It's okay. Both the cases you are withdrawing.
Withdrawn.
Mr. H.R. Chaudhary, learned counsel for the petitioner, submits that he has instructions to withdraw the matter. Prayer is allowed. Matter is closed as withdrawn.
Right.
Disposed of. Do it. Yes. Do not dispose of without any order. 21. It's an IA.
Yes, Lordship.
What is this IA for?
Herein there are two prayers, Lord. First prayer is not to rely upon a preliminary inquiry report in the disciplinary proceeding. And the second prayer is with regard to my promotion, Lordship. Herein my juniors have been promoted. In the
How can that be an interlocutory application?
Yes.
Interlocutory application is some or the other correction, mistake. But here you are saying that preliminary inquiry should not be relied upon.
Yes.
And secondly, promotion has to be granted.
Promotion since it's been pending since last 4 years, Lordship. And
Then what is the main matter for?
There
he has challenged departmental proceeding. Yes, that has been.
There you have, entire matter can be heard. Why is this IA required?
Lordship, at least that first prayer with regard to that first prayer.
Preliminary inquiry, nobody will rely on that.
No, they are relying lordship, that's the case lordship. And
That is not preliminary inquiry, madam. That is special, that was an inquiry, but conducted by a special, team of the NCB.
NCB?
Yes, the Narcotics
Narcotics?
Control Bureau, yes.
Acha.
That famous case, where Shahrukh Khan's son was involved, that case.
That case, how come it is here, not
But
in
because
Bombay?
this petitioner was in deputation there in NCB when the raid was conducted in
Oh,
the SIP.
he is the official
Yes, he's one
of
of
the
the.
Narcotics Bureau Department.
No, but originally he is from the CRPF. He was on deputation in the.
He was deputed
Yes.
there,
I was
in the
deputed
Borrow
as-
Department.
Yes.
Ah.
As junior intelligence officer there in lordship, and subsequently.
No, the entire matter will be heard. This I is not necessary.
Lordship, why I'm pressing for the first prayer, Lordship, is because Lordship, the senior under whom this follow-up action was conducted, Lordship. In his case, there has been an order passed by the Delhi High Court wherein it has been said that you will not rely upon the special inquiry team report, that is the preliminary.
No, after the
That is an-
disciplinary proceeding went on, inquiry officer appointed, must have.
He participated.
He participated, cause, show cause given, statement of allegation, he participated, cross-examination
Some of the
done.
witnesses deposed also.
Thereafter, an inquiry report was submitted, given to you. So what else do you want?
Now there is an interim order in this main case, Lordship. In the interim order, some documents are yet to be provided to me, Lordship. That has not been provided till
Inquiry report was given to you?
that preliminary inquiry.
Preliminary inquiry report, how is it relevant?
Still going on, Lordship. Half of the.
Oh, it has not culminated.
Started, Department of Inquiry is started. Some of the witnesses have deposed. He has participated. In between, the whole case is built up on the premise that the case is based on the report of the SET, which is unsustainable in law. That is his main case. But there, he did not make a prayer that the SET report should not be taken into consideration. So through this he wants to get that prayer inserted in the main case, in the original case. That can be allowed, man.
There are pleadings in the main case, Lordship.
Pleadings is there, but prayer is not there. Pleading is not to that effect.
No, what I understand is that this is not a prayer to be made in an interlocutory application, right? So you want me to hear the entire matter, it can be heard today,
Oh, Lordship.
4 o'clock.
Please, the date may be given, Lordship. Here, this issue. Otherwise, Lordship, the documents.
You mean to say your inquiry report by the preliminary inquiry report was not given to you?
Lordship, part of it was given, but part of it was not given.
No.
The allegations which were.
You had appeared before the disciplinary authority, and then you had appeared before the inquiry officer. You had not asked for the preliminary inquiry there.
That is not the case, Malad. The whole case is built in the
What is-
premise that, that report, which we are relying on, that ought not to have been, taken into effect. That is what this case is all about. But that prayer was not made in the original petition, that SCT report should not be taken into consideration, so far as the petitioner is concerned. So, through this he wants to get that prayer inserted in the.
Yes,
I
and in,
think that is petition.
I prefer representation before the authorities saying that you need not rely upon that evidence and all collected during the preliminary inquiry law. But they did not respond, and that is why the writ petition was filed. Now I'm coming before your lordship with this because they did not consider law.
but this is not done. This is, you have not prayed
Why-
for it in the main writ petition.
Yes,
And
so
then
try to
you
come to
seek
case
relief.
42 of the writ petition. What is prayer is?
And you seek relief by an IA.
Yes.
You know that relief has to be, you amend the entire writ petition, you withdraw. You amend the writ petition, you include these prayers also.
Therein, lordship, the whole disciplinary proceeding has been put to challenge.
Which will include your preliminary inquiry.
That include this prayer also, lordship, in
No,
my
no,
humble
no.
submission, lordship.
Not there. It has to be specific.
Lordship will hear it, lordship.
Hmm?
Lordship will hear it on some other days, since today there is shortage of time.
Yes.
Okay. On the prayer made by the parties, list this matter when can you?
I am not making any.
Yes, on the prayer made by the learned counsel appearing for the applicant, list this matter.
Short date may be given, lordship.
You tell me a date, suggest. I'm always there. If I don't
week,
have any disease,
The next week.
list this matter on 25th of May. Monday, 25th of May?
26 can it be option? Or 25th is a hearing then?
26th,
be
if
heard.
it comes before me, I'll be in a hurry to go to my village. So
Lordship, or let it be Lordship.
then, so 25th.
25th. Let it be. No problem.
But think over it. This cannot be by way of an interlocutory application.
He was involved, no? SCP, preliminary inquiry, he was the chairman of the SCP.
No, whatever it is, we will hear the main petition.
Yes.
Because that is a part of the disciplinary proceeding. How can you just segregate?
He has not yet Lordship.
Oh, it's not finished. Yes, Mr. Saikia?
The petitioner of the lordship was initially engaged as possible.
Yes, my lord, in this matter, what happened, my lord, I was directed to obtain instruction, my lord. Instruction they will send today or tomorrow. So let it be next week, my lord.
Acha. Instruction with regard to?
Regard to, my lord, whether minimum pay
On
scale was
19
given to him or
On 19/3/26, it was observed that instruction was there and they were supposed to file the affidavit.
Last time you had taken time that he will make his submissions on 13/5.
Yes, ma'am.
Today is 13/5.
That was, my lord, the petition of whether petitioner is entitled for minimum pay scale or not, or whether pay scale was given to him, or whether he demanded pay scale or not. That is instruction, my lord.
So when can
For
you do it then?
regarding regulation, his regulation has been rejected.
Hmm.
Because for regulation of service, my lord, there is three criteria. If the government servant and post holding against sanctioned post, it is not sanctioned post, that's why that was rejected.
Hmm.
And for earlier occasion, my lord, there was a selection process. He
Hmm.
participated, but he failed.
Hmm.
That's why his regulation has gone. So now comes to, my lord, only minimum pay scale of
Hmm.
salary, my lord. That is, my lord, as per Table 45, 2017.
So when can you make your detailed submission?
My lord, Monday or my lord?
Monday?
They are saying over telephone, my lord. They are sending today or tomorrow.
They are sending what? Instruction?
This one,
Instructions?
instruction, yeah. For Udan was a welfare office, my lord, types of welfare office.
Heard Mr. Ayat Saikia, learned counsel for the petitioner, and Mr. T.C. Chutia, learned senior counsel, assisted by
C.K. Sharma Babu.
C.K. Sharma Borna, learned counsel. Mr. Chutia submits that he is awaiting further instructions with regard to the instant matter and has prayed for some time. Prayer is accepted. List this matter again on 18th of May,
18th of May.
Monday.
Apply to.
Hey, Sabu.
May please, your Lordship. You filed a reply in this matter yesterday.
You will file.
Already filed here.
You have filed a reply.
It's not-
So,
not on record.
Mr. Borua,
Lordship, I have hampered on behalf of respondent number 6, here, Lordship.
you are appearing for us R6.
Okay. Oh, sorry, I'm taking up this, number 20.
Acha. What about this 28, Basanta Sinha? Here, you have given the copy of reply to whom?
Lordship, one affidavit has been filed on behalf of respondent number 3 here, Lordship.
We filed a reply yesterday, your Lordship.
I think that reply is not being tagged with a record if it's filed yesterday.
It's not on
Reply. Reply is not there in the record.
record. Fixed a date, your Lordship.
Hmm?
The date may be fixed now.
This one is respond number 3's affidavit is there. And
Reply is not there.
a reply is not there. Okay. Mr.
Hey, Ahmed.
A. Ahmed, learned counsel for the petitioner, submits that he has filed a reply to the affidavit in opposition filed by respondent number 3. But the said copy of reply is not found in the records. The registry is directed to place the same on the next date in the records.
Hey, date may be fixed.
List this matter on what date you want?
On 20, your Lordship. 20 May, 20 May. Next-
28, 20.
Yes, your Lordship.
Okay, 28th of February, 28th of May. That's a Wednesday, 28th of May, 2026. Mr. C.K. Sharma Borua is present. On behalf of respond number
Please, Lordship.
three,
Just a second. All the respondents also.
for all the respondents, huh? But three has filed the affidavit.
Yes, yes, Lordship.
Yes, 29. Mr. D does. Yes.
Things are complete in this matter, but fine will not be there to complete
Uh-huh.
hear this matter. Today it won't be it will be difficult to hear this matter, my lord.
Mm.
Pleadings are complete. Only
Okay.
a short issue is involved, my lord.
Also,
Whether
in fact, the record has been received today itself, Lordship, so I need to go to the record, Lordship.
let it be on 22nd, my lord. If it is
Heard, Mr.
K. Mohammed.
A.
K. Mohammed.
K. Mohammed, learned counsel for the petitioner, as well as Mr. C.K. S. Borua, learned standing counsel for
No,
revenue. No.
Lordship,
For learned counsel for the respondents, Mr. Borua submits that he received the records only today and he needs some time to go through the same and address the court.
all the.
Prayer is allowed. List this matter when?
22nd
List this matter on 22nd of
May.
May 2026.
Obliged.
Tell Mr. D does that the earlier matter that he had done, I will sign it by tomorrow,
Fine.
by today or tomorrow.
Obliged.
Lordship, I'm praying for some accommodation, Lordship.
30 to 32,
Lordship, I'm praying for
Mr.
some.
Bothakur,
Yes, Lordship. Can it be taken up on 1st of June? If
you have something to say?
No, Lordship.
Pleadings are complete?
Yes, Your Lordship.
Okay.
Actually, matter has been taken care by D. Mushahari, Your Lordship. Even she has asked me to take a time for today, Your Lordship.
Lordship, on previous occasion, certain instructions were sought for Lordship. I don't know whether it's available with them or not. Lordship. Lordship, may kindly peruse the order dated 1/4/2026, Lordship.
Mr. Khatuniar was directed to receive his instruction. On what issue?
Lordship, regarding merit list. Lordship.
To preparation of two merit
Yes,
list. Okay, in respect of two merit list. Huh? You bring the instruction
Yes, Your Lordship.
or tell Ms.
I'll inform
Mushahari?
you, Your Lordship.
Okay. Heard Mr.
P. Khatuniar.
P. Khatuniar, learned counsel for the petitioner, and Ms. H. Terampi, learned standing counsel for secondary education. Ms. Terampi submits that the instant case is being dealt by another standing counsel who has prayed for some time. Prayer is allowed and which is not objected to by learned counsel for the petitioner. List this matter on
1st of June, ma'am.
1st of June 2026. It is further directed that the instruction which were sought for should be placed on the same day, on the said day. Yes, Mr. Saikya again.
Me-
33,
No, this matter relates to, my lord, spouse posting, my lord, the petitioner's.
spouse posting.
Wife is working as teacher in Nalbari district, my lord.
Mr. Bora, you are there?
Yes, my lord. The petitioner was initially appointed on, my lord, 16/5/2011.
Can be taken for
My
disposal.
lord,
There is only 20 minutes, okay.
I'm not taking.
Additional affidavit is also filed. No affidavit in opposition has been
No,
received.
no.
No, my lord.
Not
My lord,
required.
actually, we are relying on the speaking order itself, my lord, and on
But-
last occasion, I was.
Or affidavit, but then affidavits are filed by some parties.
I have
Who?
filed a additional.
Your additional affidavit, and there is one more,
I have filed two affidavits.
two affidavits, okay.
One 16/5/2011, my lord, was appointed as multi-purpose worker.
So what is the page?
16/11/2011, my lord, page 23, my lord,
Acha, Annexure 1.
my lord.
Bhaskar Jyoti Kolita,
Pastor Kolita,
yes. He was appointed as a multi-purpose worker,
my lord.
okay.
Thereafter, my lord, he was initially posted at Boko, my lord.
Hmm.
Then, my lord, he was transferred to Simonabasti, Nogao,
In temporary capacity,
my lord.
he's not regular service.
Irregular appointment.
Where this is first, where is the regulation order?
This is the order, my lord, appointment order.
Temporarily,
It's appointment order, sir, my lord. They are covered by the new pension rules. They are covered by the new pension rules mentioned in the annexure 1, my lord.
New pension rules. So they having appointed after 2005.
Fine.
Acha, any pleadings that he was regularized?
My lord, this is the appointment, regular appointment, my lord.
Acha, okay
Regular.
then.
This is not good. Then he was transferred to my lord Nagaon.
Annexure
se-
2.
Annexure 2, my lord, 7/10/2016
Hmm.
to Simona Bosti.
Okay.
Thereafter, my lord,
As multipurpose.
same capacity, my lord.
As
What?
multipurpose worker. Huh. Then.
After around, my lord, 3 years,
Hmm.
my lord, on 21/2/2019, he was allowed to work at my lord Kotora Sub-Center under Komarkusi block, under Joint Director Health Service Nalbari.
Temporarily only.
Temporarily, my lord, to my lord, initial appointment, his substantive post is at my lord, Simona Bosti.
Hmm.
This is the attachment order, my lord. He has been
Acha.
attached at Komarkusi, my lord.
Hmm.
Thereafter, my lord, again on, this is on 21/2/2019, he was attached at my lord, Komarkushi. Then on 8th July 2019, he was again reverted back to Simona Bosti.
Hmm.
Page 26, my lord.
So he was reverted by Simona Bosti.
My lord.
Okay.
Thereafter, my lord, on 25th February 2020, he was brought back to Komarkusi.
Hmm.
He was brought back
I
to
work
Komarkusi.
temporarily and until further order
Assessment, ma'am.
on medical ground of parents.
My lord.
So he was brought back to Kamarkusi.
Komarkusi.
Ah, yeah. Then.
Thereafter, my lord, under the Nalbari district only, my lord, he was transferred to another, my lord, at Bogara Sub-Center
Hmm.
from Komarkusi.
Hmm.
Then, my lord, again, he was,
This is also a transfer order.
my lord.
Hmm. Then.
Thereafter, my lord, on 19 December 2022, he was allowed to work at Nice Bota Villa,
Hmm. Again a transfer order.
my lord.
Then.
Then, my lord, on January 2025,
Hmm.
the government decided to recall all the attachment orders.
Hmm.
On administrative ground, they have decided to recall all the attachment orders.
Hmm. All the attachment
The
orders.
attachment orders. The petitioner, as well as the other multi-purpose workers, my lord, who were working under attachment, their attachment orders were recalled.
Hmm.
And the petitioner, as he was initially posted in 2016 as Simona Bosti, he was again reverted back to Simona Bosti.
Hmm.
He is posted at Simona Bosti since 2016, my lord.
No, 2011.
No, initially, my lord, he was at Boko.
Oh, it's a Boko. Then it's to Simona Bosti.
Then by this order, my lord, at
2016. Okay.
my lord. My lord, by order at page 31,
Hmm. So he was taken back to Simona Bosti
Simona Bosti.
on January 25.
On January, he's on 27 January, the attachment order was, my lord, cancelled, and he was released on 1st of February, page 32.
Hmm. Hmm.
Page 32. He was released by the, my lord, Joint Director Health Services.
Released from his service.
No, my lord,
Original post of.
for, my lord, joining at original place of posting, my lord. The concerned, my lord, subdivisional medical and health officer, my lord, he also released on 23rd
So he was released from which place?
from Komarkusi to Simona Bosti.
Hmm.
My lord, accordingly, he joined.
Hmm.
Thereafter, my lord, as he's
Where is he in this list?
in the list, my lord, at page 70. Sorry, my lord.
No.
Page 37, my lord. Page
37.
37.
Okay.
Till number 71.
Huh.
Till number
So he
71.
was released and he was directed to join Simona Bosti.
My lord.
Okay.
My lord, as his wife was appointed, my lord, she will find the order at page 42,
42.
my lord.
Huh?
On 15/2/2025,
Hmm.
till number 21, my lord.
Hmm.
Krishna Moni Dekar.
Hmm.
His wife was appointed as, my lord, regular teacher. Earlier, she was working on contractual basis. That service will not be counted towards, my lord, seniority and other purposes, my lord. So, my lord, this is the first appointment, regular appointment, 15/2/2025.
Hmm.
She has been, my lord,
Appointed as what? Assistant teacher.
assistant teacher, ma'am,
Hmm.
in Nalbari.
Hmm. In Nalbari.
Nalbari.
Okay.
So, my lord, the petitioner as well as his wife, they approached the authority, my lord, for his transfer to Nalbari or any other nearby districts. The office memorandum at page 49
Hmm.
that provides the, my lord, policy
Hmm.
of posting the spouses, my lord.
Hmm. Then,
My lord, this is the office memorandum, my lord, under which the spouses are, my lord, posted.
hmm.
The illustrations have been given at page 50, my lord,
Hmm.
which categories of servants should be posted on
Hmm.
which.
Which will be important here?
My lord, illustration 2 will be applicable in case of the petitioner, my lord.
Hmm.
Because my lord, the petitioner is working in the health department and the wife is working in the education department.
Hmm.
So my lord, two other state services,
Hmm.
so close to.
Hmm. Hmm. To the nearest, okay. Then,
My lord.
who has the longer service?
My lord.
Who has-
I have the longer service, my lord, because I am posted at Simona Bosti since 2016.
Hmm.
Though I was attached on time and again in different, my lord, places, my substantive post is at, my lord, Simona Bosti.
Why not Boko?
Boko, my lord, from Boko, I was transferred in the year 2016, my lord.
2011 is your Boko.
2011, initially I was appointed and posted at Boko.
Hmm.
Then, my lord, I was transferred to, my lord, Simona Bosti.
Hmm. In 2016,
2016.
after 5 years.
After 5. After that, my lord, I have not been transferred. Though I was allowed to work in different places, my lord, that is on.
You were attached.
That is on attachment, not
Okay.
transfer attachment.
But longer service, to calculate longer service, your service will be counted from 2011. Still then it will be longer than your wife.
Longer than my.
Okay.
So, my lord, I approached the authority for my transfer. My wife also, my lord, she also applied. My lord, as our cases were not considered,
Hmm.
we approached this honorable court, my lord.
Hmm.
This honorable court, my lord, directed the authority at page 59,
Hmm. 59.
my lord.
Hmm.
The relevant portion is page 61, my lord.
Yes.
In view of the submission made by the learned counsel for the petitioner and not objected to by the learned counsel for the respondents, the petition stands closed. Is 61, my lord.
Hmm.
The
Close with liberty.
with liberty to the petitioner to file detailed representation, giving factual particulars with regard to the length of services of the petitioner as well as his spouse, so that the authorities may take note of these facts and pass appropriate orders in terms of the guidelines issued under Office Memorandum dated 21/5.
This is the one you had shown.
Mine.
Hmm. We'll consider his case. Okay. So that's a consideration order. Then,
Then, my lord, I filed the representation at page 63,
hmm.
giving all the details, my lord.
Hmm.
And my lord, finally, my lord, my representation was rejected by the speaking order at page 73.
Hmm.
My prayer was rejected.
Hmm. On what ground?
They say that, my lord, no, I cannot be transferred because, my lord, there is no person at Simona Bosti.
Yes.
No person at Simona Bosti, so I cannot be transferred. And I can be transferred only on the ground that, my lord, usual transfer. If I can arrange somebody to go to Simona Bosti, then only I can be transferred.
Oh.
That is the, my lord, ground they have
Hmm.
taken. But that ground, they cannot take, my lord. They are the authority, my lord. They can transfer anybody, my lord.
So you have challenged this order here.
My lord. But, my lord, while refuting my case, at page 76,
Hmm.
they have transferred one person, my lord, to Nalbari. They have selectively
Oh,
taken
they had
persons-
transferred one person to Nalbari
Nalbari at page 76.
and he was left out.
My lord, I was not, my case was rejected.
Hmm.
Page 76 is the order.
Hmm.
Then, my lord, another person, my lord, he was transferred to Gauhati at page 77.
Hmm.
Then, my lord, another person at
Okay,
page,
these are similarly situated and
79.
transfers are being made.
my lord,
So this is your case.
this is my case. My lord, while hearing this petition, this honorable court, my lord,
This petition.
my lord,
You have some interim order.
no, my lord. This honorable court directed the, my lord, learned friend on 19/12/2025 page 88, my lord. I have annexed that order, my lord.
Oh, age 88,
My lord.
yes.
Page 89 is a little question. However, Mr. Bora is directed to obtain instruction as to whether the petitioner can be accommodated in any nearby district. My lord. In the meantime, my lord, one post, my lord, that fallen vacant in Gauhati, my lord, in the Kamrup rural, my lord, two posts, my lord, on 31st December 2025, and another post, my lord, on 31st January 2026. Both were, my lord, fallen vacant, my lord, and my lord, therefore, my lord, I applied before the authority at page the representation.
Doesn't matter, okay, it had fallen vacant, but then you have to get someone to go to Salon University.
No, my lord, how can they insist on that, my lord? They are the authority, they can transfer anybody, my lord. I am not required to arrange
But
somebody.
I hear most of the time from the person who seeks transfer, you get someone from somewhere where
My lord.
get it posted.
My-
Like a layman, I'm saying, I used to hear this.
My lord,
So there are vacant posts in Guwahati rural,
my
in
lord,
Kamrup rural,
Kamrup rural.
but then they are not considering you.
They did not consider my case. However, my lord, that post were, they are, my lord, filling up by another person, my lord, other persons, those posts.
Hmm.
My lord, I have also annexed those orders, my lord.
Okay.
My case was not
Yes,
considered.
Mr.
my lord. They are-
PKR Chaudhary. Yes, Mr.
Lord,
Chaudhary.
The additional affidavit,
We are waiting for which matter? I'll not take up any more hearing matters anymore. 35. But then I think this matter will be the last I'll dictate. I'll continue interim order. Wherever there are interim orders, please let know the court master. We will extend it. Yes, Mr. Chaudhary.
case 109, my lord, 111/3/2026,
109.
my lord,
Yes, 109.
11/3/2026.
Hmm.
They have, my lord, transferred two persons to
Mm.
Nalbari,
Yes.
but they are not going to transfer me. They will transfer anybody, my lord, to Nalbari or Kamrup, my lord. Then at case, my lord, another
Then
11.
what happened to the High Court's order nearby areas of Nalbari? They did not do anything.
They do not do anything, my lord. These posts are, they are, my lord, filling up post, my lord, time and again by other persons, my lord, instead of considering my case, my lord. Though this honorable court directed them to, my lord, accommodate me, my lord, my lord, either in Nalbari or any other nearby districts, my lord.
So this is in nutshell your case.
My lord. This issue has been decided by the honorable court, my lord, in a case earlier, my lord,
Spouse posting.
my lord. It's about 55, 20.
खत्म हो गया. What is the paragraph?
Well, paragraph 6, 7, 9, 11, and 13. Paragraph 6, my lord, says about.
It's okay, I'll read it. And 6.
6, 7, 9, 11, and 13.
Hmm.
So,
Okay.
my lord, in view of
So
this,
spouse posting should be done.
my lord, in view of that, my lord, my limited.
So here he was transferred to nearby areas or what?
The other persons were transferred, the petitioner case has not been considered.
No, in this case, the case of
Yes,
the
yes.
petitioner were not fallen, however, spirit of it did not fall within the categories. Your case falls within the illustrations.
My lord.
Since in a say
In that case, my lord, the transfer order was set aside.
So it is relegated to the authority and they should decide in posting. Okay. Over?
My lord, as the persons, my lord, they are accommodating the other incumbents, my lord, either in Nalbari or any other nearby districts, my lord. Why not the petitioner can be accommodated?
Let's see what he says.
My lord.
Yes, Mr. Bora.
Yes, my lord. My lord, kindly come to page 73, my lord, the speaking order, which has been passed in person.
Yes, I've seen that.
Yes, my lord.
that where is at present there is an administrative requirement to maintain so and so at Siloni Bosti, Simona Bosti. Posting of so and so is based on field requirements and where accommodating the petitioner at Nalbari on a permanent basis will create a vacancy in his original post and may affect. So they want somebody to man that post.
Yes, my lord.
In Samari Bosti.
Page 74, my lord, paragraph 5 and 6, important, my lord.
Yes, I've seen. I've read that.
Yes, my lord. So
If he's able to arrange a mutual transfer,
my
then
the issue is not regarding the vacancy in Nalbari or nearby district.
that's what I said, that
Yes,
you
my
bring
lord.
someone to
Yes, my lord. This
man
is
the
the issue
post.
because we need someone there, my lord. It is
Why would he keep on searching somebody to come to Simona Bosti? It is your duty.
No, my lord. His original place of posting was Simona Bosti. For his personal problem, my lord, he was attached in Nalbari district for last 10 years, my lord. And for it is a exigency of service, my lord. So for administrative purpose, now his attachment has been cancelled and he has been posted in Simona Bosti, my lord. So as an employer, we can, wherever we want an employee, my lord, we can post there, my lord. Because unless and until any malafide can be shown, my lord, the transfer order is not visited by.
What about that memorandum then spouse posting? You should post
Yes,
them.
my lord, memorandum, my lord, spouse posting so far as the department can consider. But now, my lord, there is no other person in Simona Bosti to man them.
This is not a post of President of India or Prime Minister. This is a small
But
post.
for a small primary health center, this is an important post, my lord.
You get someone. Otherwise, that memorandum will have no meaning. There it is
My
not
lord,
said
it,
that the person has to bring.
My lord, I would like to rely on the division bench judgment regarding by the my lord spouse posting, my lord. Very recent judgment, my lord.
Not allowed.
Not, my lord, because
It
is
depends
not,
on facts and circumstances,
Yes,
you
my
see.
Yes. In this case also, in the given facts and circumstances, we need a person, it is regarding, my lord, health sector, my lord, not any other job, my lord. He is a multi-purpose worker. There, in that center, my lord, there is no other person, my lord. Because in rural areas, my lord, it is difficult to find someone, my lord. So he has been posted there. Even if, my lord, in the speaking order, he has been given the liberty. If you can bring someone, we will accommodate you as per your wish, my lord.
But I have known this for a long time, that person cannot search someone to come to a rural place. And
then we'll also have to run the health sector, my lord. There is always allegation from the allegation that, my lord, persons are not there in the health sector.
No, that requirement that the candidate has to bring someone, incumbent has, that is nowhere provided in any
My lord, that is
memo or
nowhere
rules.
provided, but otherwise, how his transfer order can be, it is not vitiated by any malice, my lord. And on the Honorable Supreme Court has held in many cases that unless and until it is not vitiated by malice, my lord, the transfer order
Yes,
cannot
transfer order can
Yes,
hardly be interfered. That is okay.
Yes, my lord.
It is exigencies of service, one has to go.
Yes, my lord.
But then, see, otherwise the memo of spouse transfer will be nothing, will.
That's why, my lord, I am relying on this division bench judgment, my lord.
That paragraph?
My lord, all the paragraphs are relevant, my lord. 7, 9, 10, 13.
No, the final
10,
thing.
12, 13, my lord. It's right from paragraph 7, my lord. It is also in regard to spouse posting, my lord. Then 7, 9. Paragraph 10, my lord.
And here, of course, Arunachal Pradesh, and they have not they have not prayed for direction to the respondent authority to dispose of his representation also. You have filed representations, right? And
The speaking order has been passed on the.
oh yes, that was
Yes,
rejected.
my lord.
And then
Paragraph 10, my lord. Then paragraph 12 and 13, my lord.
so maybe it was the- There will be
And
so many
if
cases
your
like this,
lordship-
but.
Or Lordship peruses page 50, clause 2 of the guideline, my lord.
Hmm.
Where one spouse belongs to one state service and the other spouse belongs to another state service. The
Mhm.
spouse with the longer service at a station may apply to the appropriate cadre controlling authority. So here the wife is posted in Nalbari since 2011, my lord.
So she actually is entitled to
Yes.
come down to Saloni Basti.
Simona Bhatti, my lord.
Simon Basti.
So
Can that be done, Mr. Sakya?
The substantive post of the wife, my lord, in the year 2025, not in 2011. The contextual period, they cannot count, my lord. If that is counted, my lord, towards, that will be counted towards her seniority also, my lord. Giving all the benefits, consequential benefits.
Hmm.
They cannot count the contextual period of service, my lord. That is not the regular service.
Here with the longer service,
Yes, my lord.
contractual will also be included.
Yes,
That
my lord.
counted, that cannot be, my lord, in, for the purpose of, my lord, counting her service, my lord, that period is not counted. Even if for seniority or for, my lord,
It is
eligibility
not
for-
said that regular service or something.
No, the role
That's
is
why
not
I
said.
asked, who will have the longer service?
Yes, my lord. Wife is serving since 2011 in the same post, the same school, my lord.
Not
Okay,
the
can
same.
it be done? He will again file a representation, you consider? Or one of them posting in either salon, that he doesn't want.
Well,
That-
You want it in Nalbari. You also have some personal.
It's quite surprising that the mighty health department, my lord, they cannot transfer anybody to Simona Basti except the petitioner. Since
Sometimes it
2016.
happens. Nobody
since-
wills to
Since
go.
2016, the petitioner is posted at Simona Basti. In
But
fact,
he was attached for 10 years in Nalbari.
No, he has
for 3
not
years.
served there. my lord.
I have served for 3 years. It is
No.
not true that I did not serve. I served for 3 years initially in 2000, from 2016 to 2019.
No, no.
Then my lord, in 2019, I was attached.
In
Thereafter,
Nalbari.
I was again reverted back to Simona Basti.
When?
Try in 2019 itself, my lord. 2019, I was transferred to my lord Simona Basti.
Okay, right. I heard Mr. Ayat Saikya, learned counsel for the petitioner, and Mr. D. Bora, learned standing counsel for
Health and family welfare.
Health and Family Welfare Department. নাই নাই মাতিব হোৱা নাই ৰ'ব আৰু লৈ লাগিব পিছত by this application filed under Article 226 of the Constitution. You are there? No. By this application filed under Article 226 of the Constitution of India, the petitioner has prayed for setting aside what? Setting aside of the order.
The
Wait.
release orders.
19-1 petitioner has prayed for the setting aside of the order dated 19/9/2025 by which the petitioner was transferred to what? By which the attachment order was cancelled
Well,
and the petitioner was directed to render his service in his original place of posting. লিখি আছা? Original place of posting in Simona Basti. That is in which district?
Nagaon district.
Nagaon, in the district of Nagaon. Full stop. The petitioner has also prayed for setting aside and quashing of the order dated 1/2/2025. What is that?
that is the my lord, release order by the Joint Director of Service.
1/2/2025, passed by the Joint Director of Health Services, Nalbari, by which the petitioner was released from his service from his place of attachment. And what is 3/2/2025?
That is the my lord, I was working under the subdivisional medical health officer, my lord. He released by this order.
Huh?
He released me by this order.
It's okay, that will do, right? And as well as the other release orders. The case of the petitioner is that he was appointed by order dated 16th of May 2011 as a multi-purpose worker in the Pukhuri Par Sub-Center, Boko Block Public Health Center. Thereafter, on 7/10/2016, he was transferred 2. Transfer and posted. Posted at Simona Bosti Public Health Center, Nagaon, under the Joint Director of Health Services. Thereafter, the petitioner was attached at various places by various orders. Full stop. Subsequently, the petitioner was released from the attached post and were directed to join in their original place of posting by order dated. What is this order dated? By order dated 1/2/2025. 1/2/2025. One to 2025, no? But 1/2/2025 we have not challenged. Oh, yes, yes. 1/2/2025. Right. It be stated here that along with petitioner, a number of employees were released from their attached post and were directed to join in their original place of posting. Thereafter, on 3/2/2025, the petitioner was released from the attached place under Kamarkuchi BPHC to enable him to join in his original place of posting. They said order 3/2/2025 is the release order. The learned counsel for the petitioner submits that in view of the memorandum, where is that? Spouse posting. Huh?
It's 49.
In view of the memorandum dated 21st May 1987, the spouse posting was provided for. And in clause 2 of the said memorandum, it is provided that if one spouse belongs to one state service and the other spouse belong to another state service, comma, the spouse with the longer service attestation may apply for his transfer, and the said authority may post the said officer to the station of the other spouse. And if no post is available at that station, the spouse should be transferred to the nearest station where the post is available. Full stop. The petitioner submits that the wife of the petitioner was
It's 42.
page
42, madam.
42.
Madam.
The wife of the petitioner was appointed. Was appointed? No.
Appointed.
Uh-huh.
Appointment order is there.
Appointment order is not there, I think. Hereby appointed, yes. A wife of the petitioner was appointed
Appointment
as
order, initial or appointment order is 41, my lord.
That is contextual appointment.
The regular appointment.
Page 41, my lord.
Page 41 is the contextual appointment, my lord.
That is also 2011.
Yes, my lord.
He is also 2011.
But my-
okay.
That period cannot be counted towards. my
You said,
service.
yes. The wife of the petitioner was appointed as a subject teacher, stroke assistant teacher in English by order dated 31/12/2011, and the said appointment was contractual in nature, which was later on regularized, right?
No, no, it's fresh appointment.
Huh?
It's fresh appointment, ma'am. The order at page 42. a
This
fresh
is
appointment.
25 order.
Yes, madam, that is fresh appointment, madam. This is not regulation order, ma'am.
After so many years.
Madam, the contextual appointees, madam, they work like that only, madam. Subsequently, madam, after clearing test, they were, madam, regularly appointed.
So she was appointed regularly after 13, 14 years. Bapre. Okay, but on the contractual basis. And that she was regularly appointed as graduate teacher while order dated 15/2/2025 and was posted in what school? Posted,
Same school. Same school.
same school,
Yes, my lord.
and
Victoria Basudeb Vidya-
same school, right?
Same school.
No,
Correct.
school I did not give in the last one, I think. To the school of what?
Balikaria Basudeb Vidya-
Vidyapit.
Balikaria Basudev Vidyapit. Balikaria.
Same school where she was initially appointed.
Point. Balikaria Basudev Vidyapit. Nalbari. Nalbari, right?
Yes, madam.
In the district of Nalbari. As such, Nalbari, by taking into account the memorandum for spouse posting, the petitioner had submitted representation before the authority concerned. No, there is a judge, he filed writ.
Page 59, madam.
No, agree, yes, by taking into account the office memorandum, the petitioner, he filed representation before this writ,
Oh, this-
submitted representation for his posting at Nalbari, where his wife was working. And it is also stated that he has a minor daughter, right? For not getting proper response, the petitioner was constrained to file one writ petition, being WPC number 3984 of 2025. And this court, by order dated 30/7/2025, had directed that the petitioner may file a representation giving his full details to the authority concerned for spouse posting. Pursuant to the same, the petitioner had submitted a detailed representation before the Commissioner and Secretary to the Government of Assam, Health and Family Welfare Department, on 1/8/2025. Any response to this? Oh, yes, that rejection order. Yes. Where is it? Where is that?
Page 73, madam.
And the Commissioner and Secretary to the Government of Assam of the said department, by speaking order dated 19/9/2025, intimated the petitioner that administrative requirement that there was an administrative requirement to maintain adequate public health services at Simona Basti, BPHC, Nagaon. And that accommodating the petitioner at Nalbari on a permanent basis would create a vacancy in the original place of posting, and the same may affect public health services in that area. It was also stipulated that government had accommodated the petitioner many years at the place where his spouse was posted by way of attachment. It was further stated that if the petitioner can arrange a mutual transfer with another eligible multipurpose worker from Nalbari district to Simona Basti, his transfer request may be accorded. With these findings, with these conclusions, the request by the petitioner was rejected. However, the learned counsel for the petitioner submits that on a number of occasions, other incumbents,
these are not mutual transfer orders. The persons who have been brought back have given the examples. They are not mutual transfer. They have been transferred single.
Right. He submitted that other employees of other departments, without insisting on mutual transfer, were transferred to the various posts in the district of Nalbari and others, without adhering to the request of the petitioner. As such, a prayer is made that this court may direct the respondent authorities to post the petitioner at Nalbari
Or in any nearby districts.
or in any nearby areas in view of the office memorandum mentioned above. On the other hand, Mr. D.P. Bora, learned counsel for Public Health and what? Health and Family Welfare, submits that transfer is an exigency of service and the same is left to the authorities concerned. Full stop.
This document also I want to rely on, my lord. It is instruction received on 24/3/2026, my lord, which says that, my lord, there is currently no vacancy of MPW at Nalbari, Borpeta and Kamrup district.
Oh. He also states that petitioner was accommodated at the place of posting where his wife was posted on attachment basis on his request for a number of years. That is more than 10 years during his service career. And that after the same, he was brought back to his original place of posting, that is Simona Basti, due to exigencies of service. He has also placed one instruction dated 24/3/2026, by which it was intimated that there was no vacant post at Nalbari of multipurpose worker. But then people are transferred before this.
Present, yeah, before that, 24/3/2026, my lord.
On 31/3/2026 also, my lord, one post like fallen vacant. my lord,
After
that is
3 days also.
At Bama
Maybe
subcenter
after
under
that, on that day.
media.
On that day it was.
They will not consider. my
There
lord,
was
they will
no,
consider other
yes, there was no, no vacancy in the district of Nalbari, Borpeta and Kamrup of multi-purpose worker within bracket M. He had relied on a judgment of this court passed in Sering Norbu, so and so reported in so delivered on so and so in writ petition so and so writ appeal, wherein it was stated that transfer orders should not be interfered with by this court. This one, it will be more Dukianable. I haven't had your son. But which paragraph you are relying?
7, 9, 10, 12, and 13, my lord.
Or ki kono? Wherein it was held that interference with transfer order. It was further held that interference with transfer orders would be justified only in cases of malafides or infraction of any professed norm or principle, and not in cases where career prospects remain unaffected and no detriment is caused. Para. It is although no longer res integra that court should not interfere with the transfer orders passed due to exigencies of service. I'll pass an order for consideration again. Because his minor daughter is there. Although he was on attachment, but then either of the spouse will make an application.
Yes, my lord. His wife may also make an application, my lord. She is having a longer service, my
But in
lord.
the input order, my lord, they did not say that, my lord, my wife is working for my lord, longer period than me, my lord. In
But
order, they did not
guidelines
say that,
says, my lord.
But then even that will not sustain because the petitioner was appointed in 2011 on contractual.
Yes,
And the wife was also appointed in 2011 on contractual.
yes, my lord.
25 it was regular.
Yes, my lord.
So longer, I think both of them has equal number of
Yes,
And
my lord.
my service was
in
regular.
these
that
days,
is my
that
second-
contractual will not cover,
Yes,
will not be
second
included.
submission, but my first submission is, my lord, exigency of service. We don't have any person there. And it is more in the field of health sector, my lord.
But Simona Bosti, where will he let his daughter get her studies?
My lord, people are residing there. People are there studying there, my lord.
Nagaon?
Yes, my lord.
Very interior place.
No, not interior. It is nearby Joflamantha, my lord.
They cannot
It is.
post-
Either of the spouse will make the application
Yes, my lord.
and it will be considered for the benefit of the child as well as because spouse posting memorandum will go for a 6 otherwise.
Giving mother is also there, my lord. In fact, medical certificate. He's also with me, my lord.
Okay, কি করলো? Purpose. And only on grounds of malafides, the same can be interfered. However, the memorandum for spouse posting cannot be lost sight of. In the instant case, therefore, it is directed that one of the spouse would make an application, would make an representation.
Petitioner will make application.
Uh-huh.
Petitioner will make that.
I mean,
Because
wait,
he has the longer service, my lord, because the contractual period cannot be counted towards her service, my lord. For any purpose, it will not be counted.
That is a separate issue.
acha, one of the spouse who had a longer period of service in his service or her service tenure would make a representation before the authorities for spouse posting. Full stop. It is seen that the petitioner was appointed in 2011 and his wife was also appointed in 2011, but the said appointments were contractual in nature. And the petitioner was transferred and posted. This was also temporary, you see,
Yes.
2011, contractual basis. And the wife of the petitioner was regularly appointed in the year 2025. The authorities it can be therefore seen that the petitioner had a longer period of service, right? 2011. Now, if we consider her 2012, 25, then to shorter and otherwise equal. Otherwise, he was appointed May 2011 and she was appointed, even if we can take into account the contractual, huh? And she was appointed in
December
2011.
That part will not be considered because you are.
And her
Any
longer
purpose-
period of service by taking into account even the contractual period. Full stop. Even if the contractual period is not considered, the petitioner would have a longer period of service. Although the attachment orders were at different places. The authorities would consider the representation made by the petitioner by considering the requirement of educating the child as well as in looking after the mother of the petitioner. As far as mutual transfer is concerned, the same may be again considered by the authorities concerned, as the petitioner was not able to find anyone who would agree to come down to Siloni Bosti. And for that, the petitioner cannot be made to stay at one place in violation of the office memorandum providing for spouse posting. I was thinking something and it went out. The judgment referred by the learned counsel for the family, for the department can be distinguished to the effect that the instant case relates to spouse posting. In view of the same, the authorities concerned would consider the representation within a period of 2 months from the date of the receipt of the order. I said that without pressing on this mutual thing, you will not find anyone, then person will be there for, okay.
At least for the minimum period of service, it should have served there, my lord.
Initially, I
Normally,
served
normal
for 3
thing.
years. Initially, I have served for 3 years, my lord, since 2016, 2019.
In other
start-
sector, my lord, the
There are
case
people
is different,
private
but
again,
in
my lord.
health sector, because there is always a hue and cry that in urban areas or in the BPHC or the mini health center, persons are not there.
And they will consider, let's see what happens.
Yeah.
Okay. And the petitioner is also directed to place a copy of this, or to submit the representation with along with a copy of this order at the earliest. Matter is disposed of. And no more, huh? It's 5 o'clock. I'm not like other judges who sit till 5:30.
Item number 90, madam. A date may be fixed.
90.
Yes, sir.
See the list. So many matters are being listed. Is it possible for anyone?
Understand, sir. Understand.
90.
That yesterday's matter, transfer matter, sorry, madam, the suspension matter.
Ha, ha, ha.
He's under suspension since 2024, madam.
Oh,
So, madam, the
I've
records,
already heard to certain
no,
extent.
madam, records came yesterday. The
Oh.
council said that she's not prepared with the records. So, madam,
So when do you want?
can it be on 19th, madam?
19th.
Tuesday.
No, in this matter. Wait, let me pass order in this matter. Item 19 likhi diba. Mr. Mrinmoy Datta, learned senior counsel, assisted by
LDEC.
L. Deca. For the petitioner, submits that the matter may be taken up on
19th or Tuesday.
19th of this month. Prayer is allowed. List accordingly.
Diploma.
You can speak to the court master and this P.K. Roy Chaudhary's matter where interim.
Article number 65 in supplementary release, Sarakuddin Bhaskar versus State of Assam. My repair is to list this case in 18 Monday.
Okay, as prayed for by the learned counsel for the petitioner, list this matter on 18th.
If possible, item number 1 or 2.
One or, no, that cannot be, that is not my prerogative to list it as item number 1. Okay, list this matter on Monday.
Item number 52. I already filed a case cost item. Just allow me to file.
It's okay, court master will,
Fresh-
and
fresh-
wherever there are interim orders, let him know, he will extend.
Fresh step. Taking.
Fresh steps.
Fresh step.
In item number?
Number 6.
Item number 6, you write, the learned counsel for the petitioner. 6
52.
or 52. The learned counsel 52, you write, the learned counsel for the petitioner is allowed to take fresh steps for service of notice upon
6. Yes. For respondent number 6
upon respondent number 6. Okay?
Madam, 42 may kindly fix the date.
He will give you, no? Whatever date you can tell him and he will give you.